Coming.
May I be permitted to mention I have suffered a termination order from the Central Warehousing Corporation, and subsequently, my lord, the single bench of this court allowed by writ petition. Before the division bench, my lord, there is a stay of the contempt proceeding, my lord. I am suffering a lot, my lord. Can it be taken up two identical matters? Very short point.
Not this side now. Next month. Mention after the court reopens. 2.5 weeks left. There's too much to be tied up. Please try to understand.
My lord, may I be
Yes, yes.
permitted to mention one matter. My lord, this matter is relates to the family pension to the minor son of the second wife, lordship. It was mentioned on the last week, and lordship fixed a date that the matter will be taken up on the next Monday. That was yesterday, my lord. My lord, that is on
Again.
because my lord, the third
Oh, it has come on the list.
my lord, it is in the list on 104.
So wait.
My lord, the last taken up date was 3rd December 2024, my lord. I
Just wait.
understand
Yes.
there was a pressure upon the court.
No pressure. This is a normal
Pressure
route. This is a routine.
My
There's
lord,
no
kindly
pressure. This is
appreciate
how the court works. Yes.
My lord, may I be permitted to mention one matter for inclusion in the list, my lord?
Inclusions you can give. It will come in the next monthly list.
Lordship, may I be permitted
No
to
upgradation. Yes.
my lord, contempt application group 6.
Yes.
Contempt application group
Which?
6 matter.
Group 6.
Group 6.
It's not on the list.
My lord.
We are telling you, give the inclusions. Whatever.
Your Lordship, may I be allowed to mention one matter, Your Lordship, on review application, Your Lordship. That was the review petitions, the WPST that was dismissed on Your Lordship in December last year. Since Your Lordship, the petitioners find some apparent error from the face of the record from the judgment, Your Lordship, that some documents that was not considered. Since Your
Tuesday.
Lordship,
Give. Where is the slip?
slip is there, Your Lordship.
Give Tuesday. 9th. Please inform.
Yes.
Grateful.
Item number 1.
I don't want to embrace your lordship. If your lordship can give a short pass over, my lord, because in this matter, but I am ready to do the matter, my lord.
Please start. Please try to understand this
My lord,
gentleman.
since
He's
my lord,
been
I have been
coming from.
instructed to appear with
Huh?
I am instructed to appear with the senior, my lord, since he is in
He will come. You please start. Where is he?
well, he is on his way, my lord.
He'll come. Let's see. Don't worry. You will start. He's been coming here for 3 weeks from Banaras. Every time he's mentioning that it should be taken up. So let's see what it is.
My lord, though, my lord, I am not on his standing on his way, my lord. On the last occasion, my lord, his learned advocate appeared, my lord. Whether he obtained a no objection, my lord.
Last time he was represented by a lawyer.
My lord.
Yes.
My lord, I was not given the time to appear, my lord, and the matter came. This file also I was not given, my lord, appeal. So I have to take NOC, my lord. I have appeared all the matters by my only single.
You have given an NOC.
Yes, sir. In previous matter. No, sir. I have not given any NOC, my lord.
In this case, on the last day, 12th August 25,
yes,
you were represented by a learned advocate. Where is he and why he is not here? Why are you appearing?
I could not come, my lord.
On that day?
Yes, my lord.
So you have appointed an advocate?
No, first matter he was appointing, and I have taken NOC in that matter. In this matter, I have not appointed any advocate.
But for the writ petitioner, there is one Mr. Indranil Munshi appearing.
Yes, my lord. That day I could not appear, so I asked my advocate Rohan Raj. He was appearing for my matter. So he told I will send one advocate to us. He has not given any answer also, my lord. In that it is clearly written that he has taken time.
So you had asked someone just to seek an adjournment.
Yes, ma'am.
My lord, what my my
You have you entered appearance through a lawyer in this case, or you have not entered appearance through a lawyer?
No, sir. No, my lord. I have not entered appearance to a lawyer.
Yes. Can we see? We don't find any vakalatnama. Why are you? Don't find any
My
vakalatnama.
lord, on the last occasion, my lord, his advocate appeared and do the matter more than 45 minutes, my lord, and he never raised these issues.
So you should have raised the issue there. How he is appearing without a vakalatnama?
My lord, how do I know, my lord? Because
How do you know today?
Lord, because on the last occasion, my lord, his
So
advocate.
before raising an objection, the least expected from a counsel is to go through the records. When you are seeing that he is in court since the last week, yesterday also we told you, before you raise this objection, before this objection is raised, to know that you can assist the court, you should have gone through the records. You want us to go through the records for you and to see whether your objection is sustainable or not.
My lord, my lord, on the
I have come from there only, madam. More than 2 decades.
on the
There is a way of doing things,
my lord, this case.
and we learn these things very early. At least the record should be inspected before you make such an objection.
My lord,
Only
he
on a
himself admitted,
presumption.
my lord, without any no objection, my lord, he appeared today, without obtaining any no objection.
When?
Today itself, my lord.
From who he has to obtain an objection?
My lord, he is erstwhile advocate, my lord, who pleaded for him on the last occasion.
Is there any advocate's appearance in the record? That is what we are asking you. Have you seen?
My lord, it is the least expected that the learned counsel appear before the court with the clean hands, my lord. It is his prerogative, my lord, subject to lordship's kind correction, my lord. He should make the submission before the court that I have only.
He is appearing in person. He is entitled to some mistakes which you are not entitled to. Then on the last day, some lawyer has appeared on his behalf. If he has appeared without filing a power, if at all an objection was to be raised, it was to be raised then. If you think that no, that lawyer has appeared on his behalf today, he cannot appear in person, then at least you should verify from the records who is his lawyer on record before raising an objection. Only on the basis of the fact that earlier some lawyer had appeared and sought an adjournment, you presume that he is represented through a counsel.
Kindly bear with me for 1 minute, my lord. My lord, this case has a checkered history. This is the 4th time, my lord.
We are only today.
My lord, in the
We have not opened the case
also, my lord.
for opening the case to everything on presumption. He has done it earlier. He must have done it today.
My lord, it is, my lord,
You are an advocate. Please try to understand what the court is saying. You are raising an objection without going through the record. If this is the way you want to proceed, you may do so.
No, my lord. My lord, my humble submission before the lordship.
And you are saying he has this mistake, he has done that mistake. He is entitled to more mistakes than you.
He took
He is
the
appearing in
from the
person.
advocate, my lord. I think that advocate should make that submission before the court, my lord. That is my humble submissions.
Who is his advocate, madam?
Sir, Indranil Munshi on the last occasion, my lord, he pleaded on his behalf on the last occasion.
He may have.
He should make
we
that
don't
with
find,
clean hands.
we don't see an advocate's name is appearing. We don't know whether he is the advocate on record. Who is to verify this fact before you make an objection to the court? You or somebody else?
My lord, may I 1 minute, my lord? Well, because my lord, on the several occasions, my lord, he filed this writ petition with the help of the advocate. Thereafter, my lord, he himself moved this application with the no objection. My lord, that is my presumption, my lord. Today also he will.
Exactly. That's what we are saying. Presumption. On a presumption, you are raising an objection. Where is the vakalatnama filed on behalf of his advocate? Let's see. Have a look.
I am not on that, my lord.
Give a,
my lord, I am.
have a look. This you should have done before raising the objection. Please have a look. Satisfy yourself.
I am not on that.
We may have missed.
Madam, only I raised this issue. Now it is
check.
lordship.
You please check. Satisfy yourself. We could have missed. All of us are humans in this room.
I have nothing.
We are all humans in this room. Check.
My lord, there is no power.
Only one line observation we made to which you are making so many submissions. As an advocate, it was your bounden duty to see the records before raising such an objection.
My lord, it is my fault. My lord, I admit.
Correct.
I admit. Well, it is my
It
fault.
is a fault. Therefore, we are highlighting it. And mistakes
Putting this
do
question
occur.
to myself, my lord, whether this Indranil Munshi, the erstwhile advocate, has no had authority, my lord, to play.
We don't know. We are not here to answer
No.
that question. We are not here to answer that question, firstly. Secondly, because he has maybe committed some mistake earlier, can we presume that today again he has committed that mistake? And can you presume without going through the records? Cannot. This is not the way. You are entitled to raise all objections, but make sure that your objection is founded on facts or some law. Not just for the sake of delaying a proceeding. You want a short passover, therefore.
The learned advocate never, my lord, on his instances, my lord, on the last occasion, the matter came up before the court.
Again, last
So
occasion.
my lord, I am just, my lord, this is my submissions before your lordship, and that advocate never made that submission that I am only seeking adjournment on his behalf because I am not the advocate. He never made
And
that.
how do we ascertain this submission?
My lord, that is, my lord,
How do we ascertain this submission? What is the point in making such submissions? That on the last date, this did not happen, that is not. We will go by the records as they are, whatever is recorded in the order sheet. There is a name of a lawyer appearing. We do not find any wakalatnama filed on his behalf. So we don't know how he appeared on that day. He is saying he has requested some lawyer to come to court and seek an adjournment because he could not come reach
never
court.
made that submission. My lord,
I
that
don't
is,
know.
my lord, if they
We don't know. None of us are. You were member of the bench. Neither of us was sitting on in the bench on that day when the matter was taken up. So we don't know. All we are saying is before you raise an objection, you are required to go through the records. And when the court is addressing you, you're looking in the mobile phone.
my lord, I'm
List
ready.
after 3 weeks.
My lord, I am ready, my lord, I am ready. I am ready, my lord.
So we limit, madam.
My lord, I am tending my apology. I am ready.
We'll take it up after a while. Not right now.
I just request you not to. Whatever I have seen, what has happened, would you also take it up tomorrow? I will do.
Sir, he is coming from outside.
I
He is
understand.
appearing in person.
But your
For 3 weeks, he has been mentioning that, look, I come from Banaras.
I'm not on.
We have not entertained his mentioning because he's not the appellant. We said you cannot mention. It is only the appellant who can mention. Yesterday, the matter was taken up.
I know.
We said he is here, we'll take it up first case tomorrow. Now look what is going on.
No, no,
You
I-
were here.
I've understood your words. I've understood. Kindly take it up tomorrow morning. I will do. Personal.
No, we will do it today because he has come. We don't want him to stay here another.
My personal difficulty, the from yesterday, the other matter is going on. It's a continuing part. Now it will be taken up. I don't know whether the judge has said that already or not. That's the difficulty. Otherwise, not. Otherwise, I could have done.
We will take it up today. We will not ask him to go back. We will not do that, sir. Please try to understand.
No, our difficulty, my lord, we do not have any rule for in-person appearance. Several high courts, my lord, have that. So we do not have.
So then let's deal with that objection first.
No, there is no objection, I tell you, lord. There is no objection. I do not want to do that. I want to do it on merit. But if you lord, give me 1 day's time.
You please see, you ask him his convenience.
Any other day, if you lord,
You ask him his convenience whether he can stay back tomorrow. You should have asked your advocate on record to talk to him.
Yes.
Tomorrow, can you do that?
I don't have any. I have to stay. That is what I can.
One has to stay. No, that's not the point. Otherwise, he has to. That's
We are not going to ask him to stay back another day.
all. Then, Koru.
Yes. Yes.
My lord, for the purpose of recruitment of the online mode, for the purpose of for the post of management trainee in the eighth discipline, including the discipline of CS, company secretaryship, an advertisement was issued. In the advertisement, my lord, it has been clearly mentioned that some of the documents, while applying online, some of the documents have to be uploaded, and thereafter, my lord, you have to sit in the CABT, that is computer-based test. And in the advertisement, my lord, if your lordship kindly allow me to place that advertisement for a moment, then lordship, I will argue, my lord.
How is the advertisement relevant today?
My lord, that is not relevant. But lordship, it is the initially, my lord, there was the history. If your lordship kindly come to the straightway in the ordership, my lord, then I will come to the straightway in the.
That advertisement, we are asking you how it is relevant today. There is another round of writ petition before this case.
My lord.
Now, in that proceeding, the single judge has allowed his prayer. He has said you appoint him without disturbing anyone, if we remember correctly. Now, after that, the division bench did not interfere with that. Now, after that, he was not appointed. You took a stand before in the second writ petition that 2 of the posts were reserved for backward class. One was
One for the total out of 4, my lord, 3 for the general category, including OBC. OBC also come to the general category, and 1 for lordship, including PWD,
yes,
persons with disability, and 1 for his OBC.
correct.
And my lord, as per this disability,
So under the general unreserved category, there was only one vacancy.
unreserved category, there is for only one.
Only
vacancy
one
OBC.
unreserved general, there was one which has already been filled up.
My lord.
Now your stand is that because the single judge had said without disturbing anyone, how we can appoint him. This is your case.
This is the case.
Then how the advertisement is relevant?
No, my lord, because my lord, if the lordship allow me to place in the initial stage, my lord. This is our case, my lord, since, and as per the, in our recent order, lordship, we mentioned that if that post, that the PWD post cannot be filled up, that will be carried forward. And that has been mentioned in the previous order also, that as per the Disability Act, if there is any PWD candidate, the persons with
So
disability.
this is for which year?
My lord,
This vacancy was for which year? What is the relevant year?
2022, my lord. My lord, the entire 3 posts, my lord, filled up in the year 2023. He came first time in the year 2024.
No, 2020 advertisement date.
My lord, advertisement date, my lord, I will. 65. My lord, that somehow in the year 2022, my lord, that is the date, but 2022, my lord.
Yes.
In the year 2022,
Yes.
my lord, the post filled up, the 3 posts, my lord, in the year 21st January 2023.
So let us see the impugned order, the order under appeal.
My lord.
That would be containing all the dates. It's passed in WPA 29434.
I can't.
WPA 29434.
29434. 29. My lord, 2956, my lord, WPA. 2956.
What is the date of the order?
My lord, 22nd March 2024. My,
Oh, that is the earlier writ petition.
my lord.
We said which is the order under appeal?
My lord, that is page
29434.
434.
Yes.
My lord, the date is, my lord, 8th May 2025.
Yes. 8525.
Item number 4. Because
What is NCL? NCL non-criminal.
Yes. Already. Right. अच्छा नहीं.
Can we now let us see the earlier two orders, because whatever direction is contained in the earlier two orders. Let us see earlier two orders. Where is the division bench order? Earlier,
My lord, division bench order.
earlier division bench.
My lord. Page 200, 204.
200.
204, my lord. My lord, 31st July 2024.
item number 122 ST161 একটা পাঠিয়ে দিস তাহলে এটা তো পরবর্তী দুটো হয়ে যাচ্ছে
Yes.
My lord, I need only 10 minutes. I will give 4 submissions, my lord, which will prove this whole process was illegal, my lord. Can I?
Yes, that is what you are here for.
My lord, in the application, lord, in the application page number 34, my lord. Advertisement, sorry, my lord. In the advertisement page number 34,
Why you are giving this? Why you want to give us? Tell us what you want to. Unnecessarily giving 4 pages for what? Your writ petition is there. Whatever you have said in the writ petition, you will.
everything is there.
Yes.
Just it is summarized.
Yes.
My lord, page number 34, selection process, my lord. Selection will be based on the marks obtained in computer-based test only. And the name of the advertisement is also.
That is not open today. That is not open today.
No, my lord, I want to show what they are saying, that how they are saying that they have given preference.
No. They are not saying they have given preference.
Sir, in their reasoned order, they have written completely that you have qualified the minimum eligibility.
Correct.
And but we are giving you preference, which is stated in the advertisement. Sir, reasoned orders are on the basis which they have rejected me.
No, they have. See, the fact is very clear. You could not upload the documents in terms of the
My
advertisement.
lord,
Just
there is
listen.
no
Just listen to it. You could not upload the document. You said there was a glitch. Due to the glitch, it was not possible. The single judge found that there is no clause saying that if you cannot upload, then you will be disqualified. So, as an exception, without creating any precedent, he said physically verify his documents. This was the judgment. Physically verify his documents, and because he has obtained more marks than someone who has been selected, if his physical verification is all right, give him an appointment, but without disturbing anyone. This is the order. Now they say that all the vacancies have been filled up. So 3 cannot be given to you because the direction is without disturbing anyone. There is only 1 vacancy remaining. That vacancy remains because it was earmarked for person with disability. and they have carried it forward. So they went in appeal. Now just see what the division bench has passed an order on the earlier case. Come to the division bench order. It looks like the division bench has not interfered, but you see what has been stated in paragraph 17, 18 and 19. So failure to upload document will not automatically result because there is no advertisement, no such clause in the advertisement. Now next paragraph. Learned single judge did not grant any relaxation of any terms and conditions of the selection process per se. So there is no relaxation granted to you. All he did was direct the appellant to consider upon the physical verification. So only that part which was coming in your way, that was removed. And then in the next paragraph, it says in accordance with law, it has to be considered. The moment it says in accordance with law, is it open to them to divert the reserve vacancy to you?
I'm not talking about the reserved vacancy.
We are only on that. Unless that vacancy is available, how you can get an appointment?
My lord, two things which has not been heard in earlier courts, my lord.
No, then it cannot be heard now. That issue is closed.
No, my lord,
We cannot reappreciate everything today.
no, my
We
lord.
will have to go by the judgment because see, the single judge passed a judgment on your writ petition. The division bench has finally settled that issue. So this now cannot be changed. Whatever has been recorded in the earlier division bench cannot be changed. You are bound by what has been stated there. It has been stated that if there is a vacancy, you are to get it in accordance with law. So how you can get it when there is no vacancy? That's the only issue. Now we cannot look what are the terms of the advertisement. All that is not there. Because you have scored good marks. You have not challenged the advertisement or anything like that. So where is the vacancy for you? That is the only thing that has to be seen.
My lord, I am having,
In which vacancy you can be considered?
my lord, first thing, the person who was appointed, she has already resigned. That is the first thing. That still that post is vacant. And the second thing, my lord, if this
No, where is that? Where is that in the single judge order? Show that there is a person who has resigned.
she has resigned right now.
So your claim will remain pending for all times to come.
My lord, I am saying just,
So someone may resign, someone may retire next year also. Then it is that post will be given to you.
my lord, I am saying that, can I? Sir,
Nothing.
my lord, power to create supernumerary post in case
There is no direction. There is no direction.
unfair selection.
There is no direction by the court. That's why we are saying you have accepted the division bench order on the earlier occasion. That division bench order binds them, it binds you also. So now we cannot travel beyond that division bench order. There is no scope. You could have raised these issues. You could have said that no, how you have said only against these 4 posts, it should be, there should be a supernumeric post created for me, but you have not said that.
But the division bench order says that, my lord, on the basis of law and terms and the impugned order before us. And the impugned order clearly specifies
Which impugned order?
earlier bench, single bench order.
Yes.
Single bench order, my lord.
No, single bench. Please read paragraph 18, 19 of the division bench. The division bench was very careful without disturbing the single judge judgment. It has.
We find no merit in the present appeal. For the abundant caution, we clarify that the appellant is at liberty to deal with the candidature of the writ petition in accordance with the law and in terms of the impugned order before us.
You read paragraph 18.
Consider the candidature in accordance with law upon physical verification. So I was eligible, my lord.
No, where are you reading?
My lord, my marks are 126 and there.
Who is saying not that your marks is not 120? Who said that your marks is not 126? Where is a vacancy? That is the only thing, nothing else. There is no vacancy. How it can be given to you? Cannot be given. The single judge could not, if the order is sustained of the honorable single judge, it will amount to undoing the division bench order. This is exactly what the division bench has clarified. That only thing which was done is to accept your physical verification instead of online. Nothing else was done.
My lord, but this is purely injustice to me, my lord.
Maybe you feel that way. We
No, my lord,
understand.
the document which they have given chances to other candidates, my lord.
They may have. They have not got order of the court. You are now bound by the order of the court. You cannot travel beyond the court's order. It is not
My
open
lord,
for you.
point number 90 clearly says that in law and in
All
terms
right.
of impugned order
All
before
right,
us.
all right. That we will consider.
So the previous order was clearly stated, my lord, if he has more marks than any of the candidates selected, he must be appointed. He shall be appointed.
Only thing is, it's not whether you have more or less marks. Who is saying you don't have more marks? Who has said that you don't have more marks? Have they said that you don't have more marks? Who has said?
But the selection process is illegal, my lord.
Then you should have challenged the selection procedure. Then you should have challenged the selection procedure. You did not. You want appointment under the selection procedure. How you can say it is wrong? Wonderful.
My lord, kindly see the selection process and
No, we are not going to see the selection process. We cannot. We have to confine to the case before us. It is not an endless
previous
litigation.
order, my lord.
Previous order you can show.
My lord, there clearly it was in my favor that to give appointment within 4
Correct. So that we understand. It was clearly in your favor. Single judge said you give him appointment. Division bench clarified that. Now we are bound by the division bench
single judge
clarification.
again, my lord, he has given up.
Correct. So now whether the single judge can do so, can the division bench order be turned over by the single judge? Cannot. That is the whole thing. Yes, take down. Hurt Leonard, advocate.
Item number 2.
That I appear for the petition.
You have got the account numbers? Nirban is the son.
Yes.
You are the son. You are for the sister. What is her name?
Shikha.
Shikha. What all dues are remaining?
Allotted the,
All the dues.
yes, allot page 2 of my instruction. I have handed over my allot paginated copy. That the allot heads.
Oh. GPF, death gratuity, group insurance, and areas of pension.
These are the heads.
So who would be the competent authority for
Allot allot it shall be from respondent number 3 to 4. 3 and 4. Agricultural chemist where he was, the employee was working, and treasury officer will be the disburse.
the petition? Make a report. If the election is we are direct. We are record. So we can't wait. That's sufficient.
Can I get a copy of the mediation? Audacity was reflected.
Don't get into. Best possible scenario. Item number 3.
Well, item number 3, I am appearing on behalf of the Life Insurance Corporation of India applicant. Well, being aggrieved and dissatisfied with the order of the Honorable Single Bench, we have preferred an appeal, my lord.
You are the respondent in the writ
I
court.
am the appellant.
In the writ court, you were a respondent.
Yes, yes, my lord. My lord,
What is the direction passed by the writ?
well, my lord, after admitting my appeal on 27th March 2025, Honorable Justice Taprapati Chakraborty and Honorable Justice Ritabrata Kumar Mitra have allowed my appeal and direction towards the payment of interest. I'll kindly page 3 of order dated 27th March 2025, my lord. Paragraph, second paragraph. In view thereof, the direction towards the payment of interest at the 6% shall remain state till the end of April 2025 or until further order whichever is earlier. Thereafter, the in ad interim order extended till 30th 11 November 2025. My lord, in this portion, my lord, we have already paid the one-third amount to the widow and mother-in-law. The retail benefit of the husband of the petitioner, my lord. My lord, if your lordship kindly trouble to turn.
So why only 1/3? What happened to the remaining one?
Direction, my lord, direction given by the Honorable Justice.
No, you said 1/3, 1/3
1/3 and 1/3
to the mother and wife.
mother and
What
wife.
happened to the remaining 1/3?
Remaining 1/3, Honorable Court has been directed to deposit in. Well, kindly see the order of the Honorable Single Bench, my lord. Kindly see.
No, tell us first. You are telling us what happened to the remaining 1/3.
Remaining 1/3 amount shown should be retained with LIC and interest-bearing account as per direction of the court.
For what? Why that 1/3 is to be remaining?
Yes. My lord, there is
There is one more claimant.
the son, the wife, son, and mother-in-law.
So mother-in-law and wife have agreed and they have got 1/3.
1/3
1/3, the son's claim is still pending.
still pending because as per the order of the Honorable Single Bench, the order has been the amount has been retained in the LIC, I mean. And LIC and the order and also the direction upon the LIC. The LIC.
So then what is your problem?
My lord, LIC on being satisfied the son is a major, is able to look after himself, shall part with his share of the son. But there is a clause, my lord. In order portion, there is a clause.
What is the clause?
What is the clause is if LIC on being satisfied that the son is a major and is able to look after himself, shall part with his share. My lord, it will be open to the son who, according to the petition, is a major to approach the LIC with proper documentation for receiving 1/3 share with accrued interest. If any LIC on being satisfied with the son is a major and is able to look after himself, shall part with a share of the son. Now they have filed an application. My lord, on last occasion, in earlier occasion, Honorable Division Bench has given liberty to the respondent to file an application. They have filed an application to add his son as a respondent in this appeal.
See, if we have understood what you are submitting correctly, there is a direction. Somebody's retirement dues he was your employee.
He is my employee.
He was your employee, so you are bound to give him some retirement dues.
Yes.
There are 3 claimants. For
Yes.
2, the court has said you give 1/3 with interest. For the third person, it has said if he's available, if he wants, he can go and take it.
Yes. If he's major.
So what is your problem? You have to give it anyway. Why you are here in appeal?
Appeal is not for the same. We have preferred an appeal for interest part, my lord.
You don't want to pay interest. That
Yes,
is
yes,
the only
and
thing.
that is the point, and also the interest has been stay by the Honorable Division Bench, my lord, earlier occasion. Only interest portion.
So
Because
this amount,
that time the widow and his mother-in-law.
this amount became payable on which date?
Which amount?
When did he retire or die? What is the date on which the amount became payable?
Well, after
It is on 4/9/2023. It's on 4/9/2023.
What happened? He died on that day.
He was ablaze. He was on fire while on duty. And this was 2023, and subsequently,
You are for?
I am for the wife who initially moved the writ petition, and subsequently I have already made an application for addition of party for the son, who is not getting the funds in spite of being made available by the trial court itself, that he will be getting 1/3 of the amount.
Son, why he has not come forward?
Now he is over here.
he is not
At that material point of time, the wife came that since my husband's retirement dues are not being paid, so I came with a writ petition. Now, clear off my retirement dues of my husband. Subsequently, the mother-in-law joined the scenario. Mother-in-law and this wife is in the scenario, being asked to be paid 1/3, and automatically son is also entitled to 1/3 as per the Hindu
So
succession.
therefore, we are saying if there is no dispute amongst them, why are you here in appeal?
He is unnecessarily keeping it on
My
hold.
lord, this is all. I have not an issue, my lord. The issue is, my lord, kindly see the order. Kindly see the order of the Honorable.
How much interest has been awarded,
My lord,
sir?
interest is not because
Interest
interest has
is
been
one
stayed because
part
there
of the
is
story.
civil dispute between the mother and between the widow and the mother-in-law, between the civil court. Before the civil court, there is a dispute, and the civil court has been pleased to pass an order of injunction, man. That's why
So that injunction will prevail over the High Court.
that injunction, or therefore, no, before
Sir,
they are filing the
sir,
petition,
just
before
please,
filing the
please, calm down. They have 10 claims in the civil court. One claim they have agreed upon in the writ proceeding. What is your problem? They will fight it out for the remaining 9.
Yes.
no issue. I am only relying on the interest portion. Malik, kindly see the.
So therefore, we ask you, what is the interest awarded?
It has to be calculated, my lord. I don't know.
What is the percentage of
6%, my lord.
6%?
From the-
Only.
6%.
Now, what about
6% per annum from 5th September 2023 until payment. And the entire exercise for disbursing of amount to the petitioner and respondent force shall be made within a period of 12 weeks from date, failing which the rate of interest will be increased 8% on the principal amount from 5th September 2023 until repayment.
Until which date? To be paid till which date?
till the date of repayment?
Till the date of repayment.
No, 12 months will lapse on which date?
12 weeks from the date.
12 weeks will lapse on which date? What is the date of the judgment?
8 April, my lord. 8 April
8 April 24.
25, my lord.
So this lapsed in July. This 12 weeks lapsed in July.
Now, 12 weeks from the date, lapse in April 2025.
No, judgment is of April 20.
Judgment on 8 January 2025.
Oh. So in April it lapsed.
We have preferred an appeal, my lord, within time. We have preferred an appeal within time.
Huh?
Well, if you lordship kindly look into the first order of the Honorable Division Bench, file kindly 27 March 2025. Kindly,
Why, sir?
my lord, there is a. I have no issue, my lord. There is bill dispute.
We have understood what
And
you are
this is
saying.
the material fact before the writ petition also, my lord. The writ court has also observed.
What we are not on that. They may have suppressed many things. Now the situation is there are only.
Our latches, my lord. That's why we are.
We understand you are only the interest is pinching you. That we have understood.
Yes, yes.
Now the thing is there are 3 parties. There is no 4th party. They have agreed how it is to be apportioned. That apportionment was directed by the single judge. Why you will not comply with that? What is your issue in this?
My lord,
You are a corporation. How are you concerned?
I have already paid the retirement the benefits to the respondent. And one thing is which lies in the Oriental Insurance Company, the
Oriental.
personal action benefit, my lord. Oriental Insurance Company, as the Honorable Division Bench has given liberty to add Oriental Insurance Company, and therefore Oriental Company is
In the appeal.
Yes. And he is appearing on behalf of the Oriental
For
Insurance
what?
Company.
There was an accidental benefit which ought to have been given, and that is also be distributed in the forum of 1/3. That is around 50 lakhs, for which Oriental is to be inducted. They also communicated to the Oriental for such payment. And if you Lordship kindly have a look, what was the statement as far as this Oriental is concerned, is there.
No, but Oriental was not a party in the writ proceeding.
Oriental was not intended to be a party in the also, because it was this particular insurance is being inducted by the LIC itself.
Also, it's a group insurance
It's a
kind of.
group insurance.
In the group,
For it,
like
They
the
had a
Oriental Insurance
difficulty
Company.
to accrue the in order
For-
to redeem the fund.
They have a policy for having such a general insurance for
General
their
insurance.
employees.
That is around
I
for
use the Oriental
accidental
Insurance
claims around 50 lakhs to the person concerned. That is to be also distributed in the same ratio. Be that as it may for the present. In fact, they have also informed them to release the same. They are of the view, since you have raised your claim on a later date, that it is to be given a go-by. That is the reason why they have also been inducted as a party in the proceeding. What remains in this matter is,
Who is
With-
representing the insurance?
Hmm.
You are opposing the claim.
We are yet to receive the copy of the
This
petition.
department is directed to.
We
Well, I
have
will- I
received
will-
the
today
notice,
I will
but
serve.
we have not received the petition yet.
Today I will serve.
Lordship,
You should have said so at the outset. Unnecessarily, we are proceeding. So give her a copy. Let us.
Yes, yes, today I will. Well, yes, the division bench has given the direction to the department to send the copy to the Oriental Insurance Company. That's why the copy has not been sent.
So you will not give her a
No,
copy.
today I will,
We know the system, sir. It's not that we don't know.
yes.
She's your friend. She's appearing. She says she doesn't have copy. You can make it an issue
I will give.
or just give her a copy.
Yes, yes. Today I will.
Let her have a copy. Why should we proceed? She says she does not have copy of the appeal.
that is with regard to the 50 lakhs claim.
Whatever it is, we'll not take up matter piecemeal.
Yes.
Since they have been made a party, they must be able to file their.
So at the present moment, what I'm seeking, let the son be added as a party respondent.
Well, I will give. In my appeal, how he will can get
He-
paid?
This is absolutely.
Well,
He was
holding me back. You will not allow me
I
to
mean,
be
my
the
appeal, how will
party
he
to the
get paid?
Was
I will
he-
file
was-
an application. I will give.
He is coming to the affidavit stating I am holding back 70 lakhs of yours. What sort of statements are they?
Well,
Was the son a party to the writ
You are
proceeding?
Not a party in the petition, my lord.
not allow me to speak. But if he was speaking, I was just speaking. Can you allow me to speak? Just my
Yes.
application. In fact, this was, I was being directed by the division bench.
Who can prevent you from speaking?
No, that if the son is not being made a party to the proceeding, he is not getting the fund.
But
His
that
mother is
already,
under stage 4 cancer, he can't.
but already there is a direction to pay him.
I'm refraining from being added as a party.
Therefore, if at all they had to take that objection, they would have taken that objection. What?
With the blessing from the court, I'm holding it back. This is their own.
What is
Please, can you look at their supplementary?
their only objection is to the interest, if we have understood correctly.
This is the own statement. But while holding back the fund, he's moving the petition itself.
No, because they are obliged to give it with interest. They want clarity.
He's not holding back only the interest. He is holding back the fund of the son also.
Correct. So
Now, what was the trial court's order? Lordship, can you have a look? I was just giving.
no, we are not going to proceed unless every party has appeared properly. Give her a copy, then only we'll proceed.
Today I will give.
It will be a wastage of time today to hear anything in this.
Well,
matter.
allow me to file an affidavit of opposition in his application, my lord.
What if it?
You do whatever you want, give her a copy, then we will hear the matter.
Yes, yes. Today I will.
You have filed an application.
For getting the son.
CAN number? CAN number?
Can
You give her a copy, file an objection.
Allow me to file a opposition, my lord. Otherwise, as per my instruction, my instruction.
Yes, you can do it.
Allow me.
Again and again, we are telling you.
No, we are
Filing
ready
of
to-
the appeal, we are prima facie, we are not very much satisfied
No, we are
that
ready
you
to-
had any
No, we
cause
are-
other than an interest. Other than interest, you have
Yeah,
any scope for arguing.
As per my instruction, my lord, the authority will. I will take instruction, further instruction. Kindly adjourn for.
See, there are three parties.
I will.
There is no dispute amongst them as regards these dues.
Only interest.
There is no dispute that you are obliged to pay that due.
Yes, yes.
Now, in that circumstance, you have filed an appeal challenging a direction for payment of that due.
Payment for interest, my lord.
So
Only
if
interest
it is only confined to interest, why are you making all these issues? Why he is here and why she is there?
we have already paid one third to the
So,
mother,
and you are not shirking from paying it to the third person also. You are only concerned with interest.
Allow me, I will take further instruction, my lord.
So give her a copy first. You take instructions because prima facie we find the filing of the appeal. Apart from interest, if you are making any issues,
Yes, yes.
then we'll consider those
And
things.
his application, I will take further instruction, my lord. Can you allow me?
Give her a copy.
Yes.
You are give your appearance. MS so and so appears on behalf of
on Monday.
next week. Let it come on 15th, not Monday.
15th, another same thing.
Well, due to I have some difficulty, my lord, 16, my lord.
All right, 16.
16th, another same.
Court's date is never accepted by the law.
Due to I have some personal difficulties, my
No,
lord.
we understand, but it is just a coincidence. It happens all the time.
I will take
One day ahead or one day before.
It won't be the same day.
Very, very, very rare.
The only thing under the same heading.
What is the heading?
It's to be mentioned. A cancer patient. Otherwise,
Why to be mentioned? All right, under the same.
Item number 4.
only one thing is there. Affidavit service be kept with them.
Which affidavit?
Just there was service on the other side. At least on my behalf, affidavits are already being used. This service.
Affidavit of service
Affidavit service.
as prayed by the learned advocate.
John.
6 January the other. 6
Give your appearance.
That case, one person is admitted. They didn't to get with the
Things can be decided without. কোনটা? 185 পরেরটা। Page 87, the circular starts at page 87. Certification is mandatory, and at no point of time have they ever denied that I have not been extended the service benefits. Because in 2021, when they came up with a circular containing the list of the candidates, they said not to engage me further. And thereafter, within a period of 3 months, the entire panel was re-engaged. So their putting me in the list in 2021 gives an adverse presumption that my name has been forwarded as per the requirement of the circular every year.
The heading to be mentioned.
And rather, this aspect has already been dealt with by my lords in another petition, which has been disposed of. A number of issues have been covered. The benefits emanating from this particular circular has been conferred by the judgment passed by your lordships. This point was taken into consideration at that relevant point of time. Hmm. Yeah. This person has received. This order has not gone in appeal so
No.
far as my information is concerned, my lords. And one point your lordships must have.
So in your case, what is the objection? Is there any reasoned order dealing with your claim?
The reasoned order says that since I was disengaged, this cannot be made applicable to me. But my claim, my claim is a prior claim. Only when I filed the initial application before the tribunal, in course of the matter being taken up, I was re-engaged.
Your initial engagement
In 2008,
that continued up to
2021,
and then you were disengaged.
disengaged
On which
for
date?
3 months, my lords. Letter of disengagement page. मेरे को chart कहाँ गया? Page 81, your lordships. Disengagement notice is at page 81 and re-engagement at page 82.
What is the status of Samiti?
Functioning. It's functioning right now.
No, what is its status? It is NGO or it is part of the government? What is it?
The functions which the government ought to have performed is enrouted through this.
And who pays for its activities?
For the Samiti. Samiti का payment कौन government ही करता होगा ना? Minister. The chairman of the Samiti happens to be one of the MICs. So the payment, all the payments are made to the government. My learned friend shall be in a better position on that particular.
MIC means?
Minister in charge.
It's under the control of the government.
That does.
Yes, because this notice is issued by the medical superintendent and is regarding employee of the Samiti. That means they are making payment because they say there is no alternative fund for dispersing the daily. Therefore, we are asking what is the status of this Samiti? Not clear to me at least. Anyway. So you are out for 8, 9, 10, 4 months.
Because the letter of disengagement is July and re-engagement is.
But the circular you are relying upon is of 16/9/11.
16/9. Only one aspect I need to point out, because in the judgment I have found that the entitlement was those employees who have been in job for 10 years till a particular date, that is July 2011. So I'll point out another clause in the same memorandum, which is page 88, your lordships.
Page
88. Lordship will come to the 4th paragraph. Clause 5. Those casual, daily rated contractual workers who will complete
all right.
10
Got
years
it.
service.
So there is a cutoff date for engagement. Prior to that, those who have come in on completion of 10 years,
this circular shall be extended.
Cutoff date is of 1/4/10. And you say you are there since 2008. How do you certify that you are since 2008?
My lords, comes to page 22, your lordships.
22.
Page 22. It's an extra P1, the first page. The list of different category of staff working at ANM Art Training School, District Hospital, Malda on contractual basis. Your lordship will find as housekeeper, the fourth name is Mahamaya Das. This has been certified by the sister tutor of the District Hospital, Malda. And the date goes 5/11/2008, my lords.
You are at serial 4.
Serial 4, Mahamaya Das. और उसका कहाँ है? And the petitioner in the earlier writ petition is one of the menial staff who features as serial number 1, Mahavir Kumar Mandal. In the next series, after the housekeeper, menial
So
staff.
what is their objection? Why they are depriving it? Why they are finding you not fit for this?
Because the only reason that they have cited, your lordships may come to page. Page 96 of my petition, your lordships. This has been taken care in the order which has been passed by your lordships, which I have placed. May I read it for your lordships? The
We are looking
third
at-
last paragraph.
We are
It was
seeing.
found that the
So what prevented you from raising your claim earlier?
first time when did we file our the year of 22?
Because if the circular that you are relying upon, according to that circular, you became eligible in 18. You were removed in 21. For 3 years, what did you do?
Since I was rendering my services and the claim was take, we were fighting. I don't know whether there is something.
No,
in the
is
report
there
to say or
is
not.
there anything in between those 3 years to show that you have raised this claim? Because they say now your status is changed. You're through an agency. There's no question you are not covered by the scheme. It's not
So-
that you're not against a sanction post is not an issue.
So far as my claim is concerned, this was basing my claim on this circular of 2011. It is not at the option of the government that I shall, if I don't opt for it, I shall not be entitled to it. When the government has come up with a circular granting certain benefits to the employees, it's an act which ought to have been given to me rather than denying me for not claiming it.
So you can wait more.
It's not the question of waiting more. The moment we
You
were
became, what
disengaged,
we are saying is there anything to show why you did not raise the issue? You were eligible for at least 3 years prior to your disengagement.
my lords.
You have kept mum. They have disengaged you. Thereafter, you have chosen to take employment with an agency. That agency has now again posted you there.
We came up before the tribunal only when we were disengaged. In 21, when we were disengaged, we found that our service is at stake. We came before the tribunal. During
What was the relief in that way?
during the pendency of the matter, they came up with the re-engagement.
What was the relief
Relief
in
that was
that
claimed.
way?
Supplementary affidavit. By virtue of a supplementary affidavit, we have brought that application on record, my lord. So the question raised by your lordships, for which we had filed the supplementary affidavit, annexing the tribunal application. The relief starts at grade 16.
And during these proceedings, you accepted this appointment.
I was optionless. Since they came up with the re-engagement,
It's not a re-engagement. Some outsource agency has appointed. It's not their re-engagement.
this agency has just been posed. Even today, a new agency has come in, and now they are throwing people out. I don't have anything on record to show that, but last week they came up to my chamber stating about this particular thing which is happening right now.
That's all right. Those who are aggrieved today, they can rush to the court or whatever they want to do.
My rights.
We are about you. No claim raised for 3 years, and thereafter you have approached the tribunal saying that extent benefit of 6911, and then you have joined the outsource agency.
Because this circular speaks that I should not be disengaged till I attain the age of 60 years. The lordships comes to that particular portion of the.
Who is saying it does not?
My lords. So
that's nobody's case.
It was only when I was disengaged by the authority, I came up for the protection of my job.
You did. We are looking at the prayer 1 and 2 in your at page 17.
But the first prayer, your lordships will find that I am seeking a protection insofar as my job is concerned, that I should not be disengaged. And the second is, please extend the benefit of
6911. Now, during pendency of this claim, you choose to join an outsource agency. That is what we are looking at.
Had I not joined, I would have been thrown out, my lord.
You are already out. Where is the question of being thrown out?
But the matter was disposed of there in considering the submission that we are being disengaged. Sorry, re-engaged. So the entire thing was covered up.
You have accepted it. You have accepted it.
Sure. What termination? What is falling from my lordships is that during the pendency of the matter, we have accepted that we'll be working under the agency. We did not challenge that particular portion. So how can you raise that particular claim? Iska, what will be your answer to this? And kindly takes up page 94, your lordship, the order which was passed by the tribe. Why this matter was disposed of, your lordships. Page 94.
Your objection has been recorded.
Objection has been recorded, and on what lines this was disposed of, your lordships kindly sees.
What is recorded in the order is not very relevant. What is the nature of your engagement? You know.
As of date.
No, as on the date when it was pending before the tribunal. They need not say that they have been engaged by XYZ. You know you have been engaged by XYZ. It's not that you have been engaged directly by the respondents and they have given, now they are saying that you are engaged through an agency. That's not the case.
It's only when the authorities violated their own statute, I approached the tribunal well within time, my lord. The moment I was disengaged, because that circular
is anyone prevented for foregoing his claim?
The order kindly the court sees the order of re-engagement, your lordships. Page 82. Who has issued? Has it been issued by the authority? They have given a list. And what do they say there? Page 82, your lordships. The order passed by the special secretary. Is directed to say the governor is pleased to accord permission for engagement of 135 number of additional unskilled housekeeping scavengering personals against the existing vacancy of GDA at the Malda Medical College Hospital, such and such. So in view of such a notification, can I be thrown into the arena that my engagement was with the agency? An agency has just been posed just to cover up the entire situation and deprive me of the benefits accorded under the circular of 2011, my lords. And this has been forwarded to all the authorities of the government. So my re-engagement is not in the hands of the agency. It's the government who has re-engaged me.
Yes. And you were referring to some recommendation for your, you were referring to some recommendation made in your favor by some authority?
Was the
You said that earlier name had been forwarded.
My lords may come to page 33 onwards, your lordships. Earlier, these are recommendations. Page 32. There are the extensions which were granted to me from time to time. Some of the orders which I have annexed. Page 33 deals with the same. 34, 35, 36. Takes an order to recommendation. Then from page 47, the certifications of the work that I have done.
47.
47. Certified by the head of the department. 2019. Then even in 21 at next page 48, there is a certification by the HOD regarding my work. Then page 49, your lordships will find that during the COVID period, even I had worked. $50. And for working during the COVID period, the an amount of financial assistance of one, because I had suffered from COVID, that's why it was given. It's not that. Employed in the containment and management of COVID, I was provided with financial assistance. Order even says the government has taken me back, has re-engaged me. Now, in guise of this particular disengagement and re-engagement, can I be thrown out from the benefits granted by the circular of 2011, my lords?
Where is rejection of your claim?
About 96 in third orders. Page 96, your lordship have gone through that. Page 96. The only thing is my disengagement, and thereafter re-engagement stating that I do not come with them because I have been re-engaged.
Through which agency?
Samiti है ना, Samiti can review.
That is the Samiti.
Samiti तो है.
Private agency. Earlier you.
Agency is creeping in. I'm not aware of that. I have to collect the name in that even. The new
No,
one.
because they say agency and you are working through a Kalyan Samiti.
Kalyan Samiti.
Earlier, prior to your disengagement, you are not working under the Kalyan Samiti.
Even my re-engagement is by the order of the government. The judgment that I have handed over to your lordship's judgments that clarifies the entire position of the benefits that has been accorded insofar.
That judgment was only dealing with whether casual and whether
they're entitled to the benefits or not.
Yes. No, there was one more issue. One was whether casual and second was sanctioned post.
Sanction.
We relied on
Mhm.
perhaps an earlier judgment which said that there is no concept of sanctioned post for casual therefore. And since the scheme says casual, insistence on sanctioned post is not proper.
Not true, exactly.
That's not the point here. The point is they say you were disengaged, thereafter your status has changed. Now you cannot raise this claim. That is their case.
My re-engagement, as per the record, shows that it's the government which has re-engaged me, not the agency.
That
had it
issue
been
of the special secretary's order we have seen.
My lords.
But you are engaged under this order. How do we know?
Because the order, correct, it was there.
This is only a permission allowing engagement of 135 persons. This is not the order by which you were engaged.
It's a permission for engagement.
It is allowing the authorities to proceed with 135 engagements in accordance with the usual terms and conditions.
My
Where is your engagement? Under which organization? That's what we are asking you.
Any specific order of engagement has not been issued. Apart from this particular order directing engagement, there's no
The facts which are emerging from as of now, subject to what they say, is that from 2008 till 21 disengaged. Thereafter, they say under an agency. After becoming a member of some agency or staff of some
no
agency,
contract. Insofar as my information goes, this is the order on the basis of which re-engagement has been made.
where have you stated so? Is there any averment in the OA?
I don't think that effect is confirmed. जगह पे हूँ, 28 है।
What does it say? 76.
My lords, comes to page 10, paragraph 13, your lordships. The petitioner states that the Special Secretary, HSMS Branch, Government of West Bengal, by memo number so-and-so dated 8/11/21, issued an order thereby informing that the government is pleased to accord permission for engagement of 135 number of additional unskilled housekeeping scavengering personals against the existing vacancy of GDA at Malda Medical College and Hospital for 1 year with immediate effect on usual terms and conditions. Pursuant to the order dated 8/11/21, the contractual workers of Malda Medical College and Hospital made a representation on so and so before so on, thereby requesting him to allow them to resume their duties, which was suspended as per the order.
We have gone through just now. There is nothing.
There is nothing. But the fact that we are working as of date and we are being tried to be put into the hands of the agency.
That's not even stated by you.
Your pleading is not there.
That is why
I'm not, as of date, I am not out of service. I am in service. There is no contract even to that effect that I am under an agency.
Where is that averment that you are still working? You say that the governor came out with this order that their 135 may be engaged. Then you don't say that you were engaged.
My lord, kindly takes up page 86 once. That's in Bengali, not translated. You should have translated this. I did. I did. I did. This is your representation. Not given.
And your prayer, second prayer is seeking benefit of 16/9/2011. And order dated 25/2/16. What is 25/2/16?
The circular, your lordships.
Oh, that series, in
I'll
that
bring your
series.
lordship that way. That also grants certain benefits. My lords, page 90. Page 90 of
90.
9090. Item number 7. I did. Up to date. All the circulars deal with the enhancement of the emoluments. Last line of page 92. Last paragraph.
Page 92.
Page 92, the last line, the last paragraph rather.
Oh,
92. Oh, my lord. Tenure of engagement, yearly enhancement, medical benefits, and leave facilities to such workers shall be guided by the provisions of the memo dated 25/2/16.
yes, that's at 90.
Yes, that's at page 90, the main circular, subsequent one. So the benefit which emanates from the circular of 11, that merges with the 16.
But where is your claim that you're in service?
The documents which certifying, which I have shown to your lordship, certifying that I have been working from page 47 onwards, my lords.
How
It's
that
already
can be
there.
taken into
My
consideration?
disengagement and re-engagement.
Your re-engagement, where is that? That's what we are trying to find. It's not there in your way. You have not even asserted that you are re-engaged in the company.
The money that you have got working as that, what is the document? Present काम कर रहे हो क्या दिखा है? मंगवा का supplementary applicable law.
You see, you pointed out 13th paragraph.
Right.
After that, we have gone through 14, 15, 16. You do say that the government took a decision to appoint 130, engage 134 persons. That is all. You don't say pursuant to this decision, I have been engaged, I am working. Where is this essential averment?
That even better, I'll be beseeching your lordships to grant me liberty to file another supplementary affidavit, bringing on record that I'm still working.
How can you do that? That's not a fact before the tribunal.
Today, see,
Now you see, please come to page 90. Please come to page 90. Earlier it contemplated that only if 10 years. Now page 90 makes a provision for less than 5 years also.
This point was considered by your lordships when your lordships had asked for a clarification from the state respondent.
Not required, but then you have to say that you have worked for 5 years. So
This is missing from the petition. My pleadings, it's missing. यही करते हैं. Let us seek liberty to make an application for grant of benefit under this particular scheme, which will be granted to you. Engagement का फिर कुछ सवाल नहीं. I have not questioned your engagement. Agency नया मामला फाइल करो उसके लिए. That is better. Pleadings are missing. You have to understand that. I bow down to your lordships in that even. Liberty be granted to the petitioner to seek benefits under the circular dated 25th of February 2016, and insofar as other claims what he wants to pursue, he shall be at liberty to approach the tribunal once again. If I may. Because insofar as the pleadings are concerned, I cannot build up a new case coming before your lordships. But the fact remains that I should not blame anyone, but these should have been taken into consideration while putting on draft this particular issue.
he is still working. So if he is still working, that fact is not claimed by him in the OA. What is to be done?
Or your lordship grants me liberty to bring on record the fact that I'm still working by way of a supplementary affidavit, my lords.
No, but there is no claim before the tribunal. We are here to see whether the tribunal has passed an order in accordance with law or not.
That again brings to the main issue that that we do not have a record to show that I have been engaged. It's an order of engagement stating that they may be engaged. Thereafter, whether I have been engaged or not will not be reflected from.
No, but if you are working, you
I have
are the
received
only
salary.
person. You are the only person who can say where you are working, what is the salary being paid, where is the order engaging you. There must be something.
Definitely.
If nothing, an I-card may be issued by the contractor. We don't know. What is the modus?
Lordships kindly grant me liberty. I'll satisfy your lordship at that particular point, whether that can be taken into consideration at this relevant point of time or not.
Even if you bring it on record, will it change anything? Because that's an issue neither raised nor considered. Unless it is raised and considered.
Insofar as the claim that I have posed before the tribunal, it's twofold. So if in 2022, when I'm claiming the benefit of a circular of 11, that does not put me out of the race that I'm not entitled to that, my lord. I think I'll be able to satisfy.
You may claim anything, but where is the fact? That is what we are asking in your second way also.
That's a copy and paste of the first one.
Same.
Almost. I've gone through that. That's it. Then to cutting stuff. एक तो Friday হয়েছে 76 of it তার আগে হচ্ছে 9603 03 second 03 পরে nice 79 first one 29 second one that's what we question MKB 79 that's what second only should be question once
In the writ petition, have you said anything?
subsequent facts are there from page 5 questions.
In the writ petition.
The writ petition. So next, this is the application, the second application for the tribunal.
Yes, we have just gone through that. There is no change. We could not find anything.
Come to paragraph 12 at page 106.
Yes. Same thing.
The same thing has been repeated. I think we've gone through it earlier. Verbatim repetition of the maybe.
So today you are working in which office? According to you, you are working in which office?
Malda Hospital.
And what is your response? You have filed a reply.
Yes, they have.
Where is that statement? We are looking at WPST 185. Huh?
Page 3, paragraph 6. Sure. Page 2, paragraph 3. Petitioner was engaged purely on daily basis through agency for outsourcing work, and she was never engaged in any government approved sanction post. Further to the extended tenure of the petitioner from time to time in capacity of daily wage worker, and her services were utilized by the MSBP, Malda Medical College Hospital. One department. From department to another capacity daily wage worker through outsourcing agency as when he needed. Mentioned that the petitioner did not come on the scope of functions as enumerated in the government order issued the Finance Department 16 September 2011. That the notice dated 1st August 2021 issued by the MSBP Malda College Hospital due to nullity of further financial sanctions from the community, further since the engagement of the petitioner was purely on contractual basis in the capacity of worker to outsource agency. The rule against the termination cannot be changed applicable to the petitioner, that the pleadings that she had been worked and outsourcing has not been, she has not challenged. When he issued the tender notice for outsourcing, she has not challenged. Rather, when outsourcing agency was appointed, our agency appointed him. He have been working in a different post. And he has not challenged that order of termination, initial termination.
No, she has challenged.
Challenge but withdrawn
Due to re-engagement.
due to re-engagement by the agency.
By the agency.
And there is a break in service.
Hmm?
As soon as the agency appointed him, there is a break in service. And he has accepted it.
वो ट्राइब्यूनल में था ना उस पॉइंट को कंसिडर करने के लिए वो क्यों नहीं था दियो ना इस बार मंडे
And they did admission that she was engaged by the Progikol Non-Committee.
Where is that?
Page 94, 16 May 2023, order of the tribunal.
उधर बेंच है
The priority application for certificate order is number 1. Direct all designated control workers engaged on not to the engagement duties from us August captures from the notice the applicant was dedicated worker under the supervision of Progikol Non-Committee. Then Mr. Tiwari Nagir Council submits also such a notice of termination. Our presently applicant therefore it does not pay for I instead of direction responded prayer 2. Prayer 1 can you see the prayer 1?
Prayer 2 has also not been considered.
Set aside that and first the memo dated 15 July 2021. That order he has withdrawn from the tribunal.
What is the second prayer?
Second prayer has not been
responded to pay the applicant monthly remuneration of number such and such. Which is applicable.
Where is that? Which page?
Page 17 of the supplementary application. Of the OA application. OA number, first OA. OA number 675 of 2020.
Hearing.
And in September 2021, there must be a sanction post. Cross 10. In September.
So the first prayer you have not pressed that prayer.
Because of the re-engagement, it was not clear at that point of time whether they'll be put there or not.
This is the earlier OA. And in the present OA, what is the relief? Same.
इसमें एक तो पता है गाँव yeah. Present where the relief is at page 110.
Yes. Just a different order has been challenged. Second prayer is one and the same.
Order को challenge किए
क्वेश्चन इसमें बेनिफिट मांगे हैं, तीसरा में अप्रूवल मांगा हूँ, जो 135 एम्प्लॉइज का नाम MSPP मालदा मेडिकल कॉलेज से हेल्थ डिपार्टमेंट.
Insofar as the third relief is concerned, my lord, you will find direct the respondent authorities to grant approval in favor of the applicant, which is pending since long, wide memo number. इसमें क्या है?
135 number of casual related or temporary workers who are working in the establishments. Next key.
Here.
Where is the 2820?
It was not to terminate the applicable service during the pendency of the original. अरे कॉन्सेप्ट की इनमें पूरे तो
Health services.
सब कितने तो कॉन्सेप्ट तो
ठीक है, ये मांगा था, भेजा गया था बाद में 17 में मांगा था, 19 में डिपार्टमेंट.
ওদের কত মেমোটা কোথায় আছে
full memo.
এখানে প্লেয়ারে দেখি 2017
All this time, your lordship should find that there's 135 number of candidates who were disengaged. From time to time, they had asked for the list in order to grant approval to them. Your lordship takes up page 69. It's issued by the Director of Health Services.
See, this is all prior to your disengagement.
What I want to submit is this disengagement was brought about just to axe these people from the benefits of 2011.
But you did not do anything. You in fact, you did not press that relief. Now in this second way, how it can be considered?
Second thing is, so far as the second and the third one is concerned, your lordship, the third one says, we got direct the respondent authority to grant approval in favor of the applicant, which is pending since long. This is the approval which was called for by the authorities when they asked for 2,130 names for sanctioning.
Second prayer in the second way.
The third prayer in the second way, my lords. Page 110.
Where is that memo?
So therefore, this is in respect of your relationship prior to your disengagement.
Prior.
When you have not pressed that relief.
While the tribunal was passing the first order, in view of the re-engagement, because at that point of time, I did not have any re-engagement in my hand.
Where is that February memorandum? After 16/9/11, there is one issued in February.
वो नहीं, अच्छे तो 16 का circular.
25th February 16.
My lord, it's at page 90.
90.
90.
So if you can show them that you are engaged, maybe you will get some benefit under this. But then for doing that, you will have to confine yourself.
I understand what is 40 issues. वही बोल रहा हूँ, as far as this claim is concerned, accepted. Make a representation and seek this particular.
Because this contemplates service less than 5 years also, 5 to 10 years also. So if you have served for 5 years, you can show them that you are serving, then they may consider. This relief you are not paid, or you had paid this relief also. But this was not considered by the impugned order. 25 to 16 has not been considered by the impugned order. At page 96.
But that does not apply here.
Hmm?
That does not apply here.
No, but that's where is the order? The impugned order is at page 96.
But admitted position, he has accepted the termination order.
No, he admits what he is saying is his re-engagement is not through an agency. He is saying he is substantially working in the government itself.
Not in the pleading.
So therefore, since this claim of 20 has not been considered, you see the opening paragraph of page 96. And order dated 25 to 16 and subsequent amendments made thereto, but there is no consideration with reference to 25 to 16. Sixteen, 9, 11 and 25 to 16. You say therefore he is not coming under the provision of memo number 16, 9, 11. But what about 25 to 16? There is no decision.
Look, can you see? It found the applicant was engaged not as a government approved sanction post.
Correct.
That is a 2011 memo.
Yes.
The service temporary engaged worker was terminated from 1st August 2021. The applicant is presently engaged as additional housekeeping and scavenging personnel in Mother Medical College. There is no scope for consideration of the past service rendered by the part is not coming under the proviso of 16 September 2011.
So therefore what he wants to argue now is that his disengagement, after his disengagement, his re-engagement, he will be entitled to benefit at least under 25 to 16.
That is not the pair before the tribunal.
That is what you want to submit.
That has been asked to be considered by the tribunal.
That is what you want to submit. All right, take down. He will approach the authority.
the entire sentence. And here the missing of that particular pleading is supposed to.
Before the tribunal and before the High Court is proceeding, it is all on averments.
One line, one sentence was enough.
And normally the averments are very assertive. Because everything hinges on the averment. Both sides equally assert. Therefore, many times it becomes both against both, and then it is. Let's apply. It is that.
The side matter item number 1.
Well, appear for the appellants, then making accommodation for a week because of the fact the paper there is a direction for preparation. But that was not complete. That is the written manner of preparation of paper was of preparation to complete manner of paper volumes.
Time of the application has been taken out by the respondent number. Also added respondent. They have filed the addition of party application.
Everything after paper. Then let it come after the holiday. It is submitted by the
You heard the matter.
yes, we are passing through. Thus, in the facts of the present case, where an eligible family member had initially been offered appointment but chose not to accept it, and later on, alternative claimant approached the authorities, no actionable or legally sustainable claim for compassionate appointment can arise. In view of the above, the writ petition lacks merit and is dismissed. You will get the order. We just have the corrections.
Item number 7. Please, Your Lordship, my lord. I am for the petitioners, my lord. Last occasion, Lordship was pleased to direct me to file the English translation of the Bengali document, my lord. The representation. Issue for a regularization of service of the petitioner, my lord. My lord, lastly, my lord, they made the representation before the authority on the basis of the recommendation made by the commandant, my lord. That was not also considered. And my lord, kindly see the representation. Your lordship was pleased to see the representation. My lord, this is the.
No, it is not on record.
Yes, it is on the record, my lord.
Just tell us from the page.
Page, my lord, 66 and 76. This is a Bengali document, this is translation, my lord. And I have submitted the translation in time as per your lordship direction, my lord.
We'll have to go through the judgments also.
Yeah, your lordship, please.
We'll
My lord, adjourn the matter.
yes.
Rajaram and after vacation, my lord.
Yes, because in coming 2 weeks it may not
Yes,
be.
yes, yes, yes. As your lordship, please. My lord, may I permit to file the last pay slip of the petitioner? They are getting the salary, my lord, month by month.
So how is that relevant today?
My lord.
Why that is relevant today? You will file it when it is. Where is the translated copy you have already filed?
Yes. Translated copy কোথায়? Yes. ওকে দেওয়া হয়নি? ওটা ফাইল করেছো তো?
When did you file it?
I have filed on. I have mentioned the matter before, Lordship, on 26. Lordship was pleased to direct me to file, and I have the application. Kindly allow me to file. This is also the copy, madam, that copy.
One copy.
Copies. 66 and 76. আরে দুটো জায়গায় দুটো কপি দাও দুটো জায়গায় দুটো কপি দাও হ্যাঁ 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 আমার সঙ্গে না আমি জমা দিয়েছি তো সেই জন্য
What is it? This is the translation.
Then I think appeared after.
So prior to this, you have not filed.
No. Page. Yes, yes, my lord.
It's
On
not there.
26 I have submitted. Pursuant to lordship direction.
Then why you are giving again? That's what we.
As your lordship is not getting.
No, let us see. If you have filed, it should be there.
No, it's not there in the file. ভিতরে বড় হয়েছে ভাঁজ করা ভাঁজ করা ভাঁজ করা ভাঁজ করা ভাঁজ করাটা দেখুন তো ভিতরে 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 না না আলাদা দেখুন এতে আছে মনে করছে হ্যাঁ I have mentioned before Lordship 26, my lord. Lordship was pleased to allow me to file the.
So today we will take it on record. The translated copy.
But 7 to 11, my lord.
All.
7, 8, 9, 10, and 11.
You are in all.
All.
Same order. In those cases also there is a translation. No, let us see if it is in the record or not. Otherwise, again that day for this small purpose it will. Just see. There is any. See, what is this? This is it. This is WPST number. It's 3. Right. Show him. This is the document. Translated copy.
Yeah,
it is.
translated copy. Original page.
Same order. Next case. In all the cases, it is the same document.
Same order, same
No,
deeds,
same, represented the same.
same representation.
Oh, then separate order is not required. If one translated copy will serve all the
Yes.
same order in all the cases.
7 to 11.
Individual order. It can be individual, it can be common also. Huh?
Individual code of same order.
Please give your appearance and give a slip of the serial numbers.
Item number 12.
But pursuant to your lordship's direction, I have filed the paper. But starting my presenting my case, my lord, I beg unconditional apology to your lordship because page 32 to 36 of volume 1 of the paper not very good. By mistake of my officer page 32 to 37. But I have collected the fresh copies for your lord.
32 to 37.
But 33, 34 to minus 40.
33 to 33 to
33 seems to be all right.
This is a case where the
Next. Put it in the paper, otherwise how we can? Paper. Otherwise this will become impossible.
then I have to prepare this.
You can paste it along with this on the back. 34A, 34, 5A, that way you can, it can be numbered.
Then my lord, you'll not take this matter tomorrow also. In course of this day, I
Do it. Not good. Yes. Tell it. The tribunal matters are come for Monday and Tuesday. So not today means it will come on Monday.
but in course of this day, my lord, I
Do it. The back of every page you can paste it by giving a number.
Item number 13.
My lordship, a short passive, sir. My senior is coming.
All right. Not
14,
My lord, I'm appearing on behalf of the petitioner that I'm praying for an extension of time to file the affidavit in reply, my lord.
How much time?
1 week, my lord.
As prayed, time for filing. 15th. Just on 15th.
15 15,
Only yesterday evening, my lord, I have done the opposition, my lord, from my lord, have to file my reply.
Yesterday you have been served.
Yes, sir.
On 11 November, you said it will be served in the course.
I tender my unconditional apology, Your Lordship. The concerned officer was not available. That's why there had been a delay, Your Lordship. Both the affidavits have been.
Opposition.
This is 15th December.
10th December.
Item number 16,
16, Your Lordship, I have handed over the.
That one also you are filing.
Yes, Your Lordship, I have handed.
Same order.
Seventeen,
I'm appearing on behalf of the state petitioner.
Take his appearance.
item number 18,
Yes, my lord, I appear for the petitioner. My lord, this matter, my lord, is absolutely similar with that of my lord 121. 121 matter, my lord, was heard by the honorable bench with Justice Supratim Bhattacharya, my lord. And my lord, we have also filed our written notes of argument. Hearing, I suppose, my lord, concluded. And in the meantime, my lord, change of determination, my lord, is absolutely, my lord, horizontal reservation is a promise, my lord, under the advertisement. We participated in
121 of
today's list.
no. Oh, today's list.
This matter was heard, and matter was
for orders.
The core issue, my lord, is absolutely same.
WPST 99.
Yes.
WPST 99.
Biplav Haldar.
तो फाइल है क्या? 99 का फाइल है। It's arising out of the same process.
It is arising out of the same, not same process, a different process, but the core issue is same. If horizontal reservation, fixation.
That may be, but if it is not
But
arising out of the same process, then it can proceed. Unless it is in respect of the same recruitment process, it need not await.
Kolkata and West Bengal police, two different advertisement, but the core issue is same because Biplav Haldar, if this is Millard, the issue, if the principle is same, then Millard we have submitted. If your lordship wants to see Millard the file of Biplav Haldar, we have filed our written notes of argument. If your lordship sees it, combined cut-off marks was a decision of the authority which was absent in the rule, and Millard, that is reason whereof Millard
Will have to come once. It will have to come once. Once
kindly
it-
tag it Millard with this.
Yes.
Kindly Millard takes it away. We will serve a notice to Mr. Tapan Mukherjee, additional senior advocate.
And who is the
But
I'll have to be tagged. Why they have to be tagged? Unless it is from
because Home Guard and Civic Volunteers both are under the horizontal division.
no.
If he says no, Millard,
Both are under
horizontal division, 10% reservation. And the same issue combined cut-off mark.
Otherwise, so completely.
See, one
Is not in Biplav.
in
And I respect his confidence, Millard, from the bar. But since bench is very cautious while dealing with the issues, we can say anything. Millard. Ultimately, your lordships will have to write, and your lordship have to be very cautious. So I respect his confidence. The issue is same. Selection process, one is governed under Millard the Calcutta police regulation.
no, is it arising out of a common advertisement?
Not a common advertisement, common law, common issue.
But that is
Horizontal-
common to so many cases. That does not mean all have to be heard
because,
together.
Millard, I say Millard because this matter was heard extensively. If your lordship takes it up, let us examine. If your lordship finds, he says Advocate General wants to address. If he says your lordship fix a date, I will address.
Yes, I will come back with the proper instructions and Lord, I will satisfy the court. Lord, if your lordship
With
Lord,
full
don't take me
confidence.
because I have taken time, Lord, earlier occasions. Lord,
With full confidence.
no, Lord, I'm sorry, Lord, your lordship.
He is saying with full confidence.
No, Lord, he's actually he loves me so much.
That is why he respects your
Actually,
confidence.
my son also is admirer of my son. Yes.
So let us keep it the other side of the holiday now.
But
Will not be
this is
possible.
This is not the case. They were similar.
He wants at least a week. Then we have hardly 1.5 weeks left. It will not be possible. Therefore, we are saying.
But your lordship knows, Millard, that I cannot continue very long, Millard. At least 10 to 15. My capacity is very limited. I cannot.
No.
run the
This is
show.
not correct.
Yes, we very well know that.
Yes, why not?
You are right. You are right.
Each and every submission will
Submitted
be
by
ordered
Mr. Basu.
ডেট দেয়নি দুটো একসঙ্গে রাখ
ওই কেসে ওই ডাব্লিউপি নাম্বারটা বলবেন?
WPST 99 of 99 of 24.
Thank you.
Item number 19.
No, that bench will have to be constituted. How can I list direct for listing today? Just a minute. Just a minute. But for that matter to be listed, we don't need an assignment.
But your lordship is not subject to correction, is not required to reconstitute the bench with that bench because since the matter was heard 6 months ago, so it has to be heard by the bench having determination. Bench having, because my lord justice had not the opportunity to hear out. So my lord, this has to be heard by this bench having a determination. There is no requirement for reconstitution of the bench for this purpose because this was not treated as a part heard.
No, therefore,
This is
by us.
so there is no necessity for your lordship to sit with that honorable judge.
So in WPSC 99, WPSC 99, just pass an order list after the holidays. Give a date.
5th of January.
No, 1 week after that.
1 week after.
Print case number. Item number.
In 99, there is an order for listing on 13th of January, 1 week after 5th. Just now gave the order, and in this earlier case, we have.
কবে আসবে?
1 week after 5th.
Whatever is the date.
13th. 13 দুটোই আসবে 13
Lord, in this matter, my lord, affidavit in opposition filed by my lord. Yes, I found my lord and served upon me, my lord. I want to. Yes, I want to file my lord affidavit in reply against the affidavit in opposition.
How much time you want?
My lord, 1 week.
Affidavit in opposition is taken on record.
Please, Your Lordship. My Lord, this is the study leave matter, Your Lordship. Initially, Your Lordship heard me, Your Lordship, and Your Lordship opined that I need to show the importance of studying further with regard to a diploma, a person holding a diploma in pharmacy, and for his higher studies going for Bachelor of Pharmacy. As the state has twice rejected by application, initially by a non-speaking order, the said order was set aside, and the respondent number 2 was directed to reconsider the case. They again they rejected the applications of the petitioner. Again, my lord, without considering the representations of the petitioner. Your lordship would kindly take my application. Lord, the application is at page. Lord, it is at page 68.
Yes.
The state appeared, my lord, your lordship granted them time twice for filing their affidavits. They did not come forward. My lord, kindly take page 68. This is the application being made before the respondents seeking leave my lord, to for the study leave. I'll place this, your lordship. With humble submission, I, Kaushik Ranjan Dhara, attached to Khejur Beria, this pharmacist, since 1/6/2023, pray before you that I have earlier submitted an application to your estimated office dated 21/3/2024 for NOC for appearing in the JEE LET 2024 Common Entrance Test for lateral entry for Bachelor in Pharmacy conducted by WBJEEB. The JEE LET 2024 exam was held on 29th of June 2024 and the result was published on 2/8/2024, and I have secured a rank of 234 and successfully ensured a seat in the De Rosio Pharma Institute, Moina, Purbo Medipur, to pursue Bachelor of Pharmacy for the academic session commencing from 2024-25. In the regulation 9.2 of Chapter 4 of Pharmacy Practice Regulation 2015, it is mentioned that pharmacists shall update the knowledge of drugs through continuing education program for promoting of rational drug use. The regulation 9.3 of Chapter 4 of PPR 2015, it is stated that pharmacist is responsible for patient counseling with discussion of severe side effects, adverse effects, therapeutic contraindications of drugs. The pharmacist is authorized to undertake process and outcome research, health promotions and educations, and provide health information, also to undertake the pharmacoepidemiological studies. I completed my diploma in pharmacy course in 2013 as per Education Regulation 1991 for diploma course in pharmacy. Now the syllabus of DPharm has modified and the important subject like pharmacotherapeutics, that is directly involved with patients' care, has included in the Education Regulation 2020 for diploma course in pharmacy. It is not possible to have any knowledge about the subject. Pharmacotherapeutics for me, as the mentioned subject, was not included in the old syllabus of DPharm Pharmacy Education Regulation of 1991 and Pharmacy Education Regulation of 2020 are attached here with this. So I want to update my knowledge through pursuing BPharm course to provide better patient service and to promote the rational use of drugs that will also help the government by reducing the cost of healthcare. After completion of the said course, I shall be ready to involve myself in any kind of projects related to betterment of public and patient services implemented by the government in future. I earnestly request you to allow me to take admissions and pursue 3 years degree course with study leave and other leave as admissible as per existing rules in the interest of larger public service. So in details, Your Lordship, this application was made. And this application was initially, Your Lordship, turned down, was set aside. My Lord, the regulation, the pharmacist regulation has been also annexed out here. My Lord, it starts from, Your Lordship, page 70. And 9.3, my Lord, is there. At page 77, chapter 4. The next page is 78. 9.2 is there. 9.2. 9.2, Your Lordship, speaks of pharmacists for promotions of rational drug use. To promote.
78.
Look, page 78. Your Lordship. And my lord, 99.3 is there. It speaks of the patient counseling. And petitioners, my lord, in petition paragraph 12 to paragraph 16 of the said application that's being filed before the learned tribunal, it specifically deals with, Your Lordship, that why we are trying to state that why the petitioner should have been allowed to pursue the to avail the study leave for pursuing the course. My lord, my senior is here.
সেকেন্ডটা এলো কেন? ওই পেপার বুক গুলো নিয়ে গেছে, ডক্টরের পেপার বুক গুলো নিয়ে গেছে। 79 of 25.
The order forming the basis of the case is page 123.
123. Right.
Page 123.
Yes. That is the second rejection.
Yes, after reconsideration.
After.
And then the tribunal has again rejected.
No. Tribunal passed an order. Last page, Your Lordship sees not. No, last page to no. Yes. That is the order of the register of the tribunal. Since no bench is available, the record is placed before learned registrar in charge for fixing a date. The matter is taken up by the learned registrar in charge by notification number so and so, dated so and so. This application has been filed by Kaushik Ranjan Dhara under section 19 of the Administrative Tribunals Act 1985, wherein he has prayed for an order directing the respondent authorities to cancel, withdraw, and set aside the impugned order dated 12th August 2025, issued by the Director of Health Services, Government of West Bengal. The applicant has also prayed for other consequential reliefs. Mr. So-and-so learned advocates for the applicant are present. Let the matter appear before this bench on 6th January 2026 for admission hearing. Notice to be served in the meantime. So, on 6th January, the matter has been directed to be placed before the registrar. So, no, in fact, no judicial order. This is simply things are moving from this date to that date.
Not moving. Things are not moving.
Stalemate.
Yes. So let us see what's wrong with this order.
Yes.
20th August 25.
Yes. That is the order.
Order is of 12/8 communicated
Yes.
by a cover letter of 20th.
Yes. Yes. Reasoned order pursuant to the solemn order dated so and so. Whereas the petitioner Sri Kaushik Ranjan Dhara is working as pharmacist, group 3.
What has not been considered? According to you, what was required which was not considered?
But the regulation was, in fact, Your Lordship kindly sees page 125, last 3 paragraphs.
Yes.
And whereas the duties and responsibilities of all pharmacists are same, irrespective of his or her educational qualification, be it B Pharm or D Pharm. And whereas there is no additional promotional or financial benefit in the pharmacist cadre having B Pharm qualification. And whereas it appears that the proposed course of study, that is B Pharm, availing study leave shall not be definite advantage either for the department's point of view or from public interest point of view. And whereas there is a shortage of pharmacists in different health facilities under this Department of Health and Family Welfare, and if study leave is allowed to pursue B Pharm course, 3 years course, the petitioner will remain absent from duties for 3 years which will definitely cause hamper to the smooth functioning of the concerned health facility, catering health services to mammoth population. And whereas it is thus infructuous for a person to apply study leave to pursue B Farm. In the case of Rameshwar Haldar, he was allowed as compliance to the direction of the Honorable Calcutta High Court in WPA number so and so. And whereas in comparison to B Farm course, M Farm course is a higher qualification than minimum requisite qualification, and it is a 2 years course. Hence, Srimati Tanoya Chongdar was allowed as her additional qualification can be utilized by the authority. Now, therefore, the prayer of the petitioner is considered adhering to the government policies, prevalent rules, and natural justice, but the authority is unable to allow the prayer of the petitioner in the interest of public.
79
So, in
79.
in case of Rameshwar Haldar, in terms of the order passed by this honorable court in writ petition, they complied with. That is the sole ground. And the study leave I sought for, that was required to be considered in view of the relevant rules and regulations. That was not done.
Which rule?
Page that is annex page 78. No? Just a minute. এটা কি just a minute. Lord, it starts from page 110. Subject to the conditions specified in this appendix, study leave may be granted to a government employee with due regard to the exigencies of public service to enable him to undergo in or out of West Bengal, India, a special course of study consisting of higher studies or specialized training in a professional or a technical subject having a direct and close connection with the sphere of his study. Study leave may also be granted for a course of training or study tour in which a government employee may not attend a regular academic or semi-academic course if the course of training or the study tour is certified to be a definite advantage to government from the point of view of public interest and is related to the sphere of duties of the government employee for the purpose of studies connected with the frame, work or background of public administration subject to the conditions that the particular study or study tour shall be approved by the authority competent to grant leave, and the government employee shall be required to submit or his turn a full report on the work done by him while on study leave, and for the studies which may not be closely or directly connected with the work of a government employee, but which are capable of widening his mind in a manner likely to improve his abilities as a civil employee and to equip him better to collaborate with those employed in other branches of the public service. Note, application of study leave in cases falling under clause 3 shall be considered on merits of each case in consultation with the Department of Finance. Study leave shall not be granted unless
one is very important.
It is certified by the authority competent to grant leave that the proposed course of study or training shall be of definite advantage from the point of view of public interest. 2. It is for prosecution of studies in subjects other than academic or literary subject. The Department of Economic Affairs of the Ministry of Finance agrees to the release of foreign exchange involved in the grant of study leave if such leave is outside India. Study leave out of India shall not be, study leave shall not ordinarily be granted to a government employee who has rendered less than 5 years service under the government, who is due to retire or has the option to retire from the government service within 3 years of the date on which he is expected to return to duty after the expiry of the leave. Next, study leave shall not be granted to a government employee with such frequency as to remove him from contact with his regular work or to cause cadre or service difficulties owing to his absence on leave. Maximum amount of study leave. The maximum amount of study leave which may be granted to a government employee shall be ordinarily 12 months at 12 months at any one time and during his entire service 24 months in all, inclusive of similar kind of leave for study or training granted under any other rule. So these are the এইটা এখানে তো আমার আসছে না, আটকাচ্ছে না, না ওটা ঠিক আছে, এখানে আমি তো 50 হয়নি তো। The study leave shall not ordinarily be granted at the bottom 5 to a government employee who has rendered less than these are not applicable to me. These are not applicable.
That's not a reason assigned also.
No, that is not it.
That is not the reason assigned.
But he has formed an opinion while considering, as per direction of the tribunal, the authority has formed an opinion that it will not inure any importance or it has got no relevance with the public interest. That is the formation of opinion. But the other provisions your lordship has seen that the incumbent would enrich himself for better service. That is the
Where?
Your lordship sees blood. না না আমি দেখলাম, এখনই পড়লাম তো। Training or study.
There is no concept of someone enriching himself. The concept of study leave is that it is required to serve the public. What they are saying is that qualification for appointment of pharmacist.
Kindly see 2.1. 2.1 for a course of training or study tour in which a government employee may not attend a regular academic or semi-academic course if the course of training or the study tour is certified to be a definite advantage
to
the
the
government,
not for self-enrichment.
No, from the point of view of public interest,
Yes.
and is related to the sphere of duties of the government.
Therefore, there is no concept of personal enrichment. The concept is that it has to be a study which can be harnessed to serve the public. And what they have said is that for appointment of pharmacists, it can be either a diploma or B Pharma. Therefore, even if you acquire B Pharma, you will remain a pharmacist. What advantage we will get?
But kindly comes to page 78 for once. Page 78. কি জিনিসটা
Page 125.
This is Pharmacy Practice Regulation 2015, starts from page 71.
Yes.
But I shall be referring to page 78, 9.2 and 9.3. Kindly see, Lord. Pharmacist for promotion of rational drug use. To promote rational use of drugs, the pharmacist shall involve himself in activities such as preparation of formalities, preparation of formularies both at the hospital level and at state national level. Critical assessment of promotional materials prepared by the drug companies. Disseminations of evaluated information through authorized sources. Updating the knowledge of drugs through continuing education program and also to organize educational programs for health professionals. Preparation and dissemination of patient information. Leaflets, right. Now 9.3 patient counseling. Upon receipt of a prescription drug order and following a review of the patient's record, a registered pharmacist shall personally intimate discussion of matters that will enhance or optimize drug therapy with each patient or care given of such patient. Such discussion shall be in person whenever practicable or by telephone and shall include appropriate elements of patient counseling. Such elements may include the following. Now, Lord, your Lordship kindly consider that there is a regulation of pharmacy practice that is of 2015, and Lord, if I am allowed to pursue the course, Lord, definitely Lord, that will inure benefit to the government at large, public at large. And if I am supposed to do all these things as per regulation, Lord, higher study is needed, very much needed. But কৌশিকের অর্ডারটা করছে ওদিকে থাকবে
And where is that study leave rules, study leave rule that you are showing? Which page?
Page 110.
So the study rules are applicable.
Yes.
No trainee reserve rule for pharmacists.
No, because they are not doctors, Lord, as your Lordship has observed.
Yes. Yes.
No, I'm for the board, madam, for the West Bengal Joint Entrance Exam.
For the?
For the West Bengal Joint Entrance Exam. Not the
He has qualified that exam, therefore he has.
The state is answering this one.
State is not appearing. Heard, learned senior advocate. Your appearance.
None of you.
I'm for the petitioner 21 and 22 similar matter, connected matters. I'm led by Mr. M.N. Roy. It was directed to file affidavit in
My lord,
opposition.
we had taken a preliminary point of maintainability, my lord, since the matter is already the issues that has the prayers that has been made in this application is already made before the learned tribunal, my lord, and the matter is pending before the learned tribunal. However, my lord had given a direction to file an affidavit in opposition, my lord. I would seek an extension, my lord.
For the time required for filing.
One week for the reply.
13 Jan.
1 week for the reply. If after.
You have not heard the order. We have said 22.
Same.
Opposition has filed.
My lord, the instructions from the department has come a day back, my lord. We need a week's time, my lord.
Same order. You file it within 2 weeks.
I left.
The 23, 24 similar matter.
Your Lordship, Mrs. Sushmita Chakraborty is appearing in this in item number 23 on behalf of the state, Your Lordship. Due to some medical emergency, she had to leave court, Your Lordship. I was.
She told me that on account of her daughter's illness, my lord,
she had to take her daughter to the doctor, Your Lordship.
Your Lordship takes it at the next week, my lord.
As prayed by the learned advocate.
Yes, my lord. 27.
So you are appearing 25.
23.
Oh.
23, 24, same.
Same order. Same order. I'm grateful.
Last occasion, Your Lordship.
What is sir?
Yes, Mallet. Last occasion, GP was appearing, Mallet.
So he is appearing now.
And Mallet.
No, last occasion, no, state council was not appearing.
It was extensive heard ballot, and that day Your Lordship was opined that the not let it not today the matter.
216.
Yes, 216, Your Lordship. Your Lordship heard out the matter. Then after at 3 p.m. when the Lordship convinced the bench, the Lordship directed that the matter.
Order. Show him.
After this matter was taken up. It was Friday, last Friday. Yes, my lord, it was heard, my lord. The last order, my lord, what happened? Your lordship dictated the entire order. Then after at 3 p.m., your lordship resumed the court and directing upon the court officer not to pass, let it be not today. And there was a call from the court officer that the
So therefore, because the state was not represented.
no, state was there, my lord. On that day, Mr.
Then where is the
This is, my lord, that is what was the date I'm asking?
Last Monday. That's the last time they probably listed.
So Friday.
Solo.
give it.
When it was called.
That day there was no order. We had clarified that there will be no order.
On that day,
So
the learned
therefore
advocate.
you cannot rely on the proceedings of that day.
Yes, my lord, that is there. But they have appeared. That's simpliciter. I'm saying they have
They
appeared.
are appearing. That is a different thing. Yes, we can proceed.
And so far, the recent development has taken place, my lord, with regard to the petition number 6.
What is the issue?
Issue, my lord? Reduction of
Just because you remember, we don't remember. Yes.
The issue was that, my lord, the two applications before the state administrative tribunal is pending, and that is reached up to stage of the final hearing. And then after, my lord, there was a reduction order. I preferred an MA application. The MA was disposed of by directing any decision with regard to the reduction of pay, you must issue the show cause to the applicants. Reply thereof, then you take the decision. Against that order, my lord, they already reduced by pay. Being aggrieved, my lord, I preferred a content application before the Honorable State Administrative Tribunal. And State Administrative Tribunal changed the flavor content of that order in a contempt jurisdiction. That is the order impugned here, lordship. And the pay has been reduced without giving any so cause, without furnishing any reply thereof. Therefore, my lord, I am challenging the impugned order passed in the contempt jurisdiction by the State Administrative Tribunal, my lord. And the tribunal is not in session, my lord. Therefore, I constrain for the protection of limited protection, my lord, because the original application is already pending, and that is at the final stage. By the time they are my prayer with regard to the protection of pay, not in isolation, rather this particular protection has already been granted by the coordinate bench of this Honorable High Court. Akin to that particular provision, my lord, I prayed that I should be similarly placed. So let this particular protection be conferred over to me till the outcome of the original application. Your lordship will remember, my lord, recapitulation. Kindly go to the order impugned, your lordship. That is the last page, my lord.
Where is the direction of 22.5?
Yes, 22.5 is ballot at page 161.
Oh, yes, on that day we were rising because of some resolution.
Yes.
Now I remember. So you were a party to this order?
Yes. Because the OA number 164 of 2016 was order is annexed as page 30 ballot. Kindly peruse that order. That would be clarity of the coordinate bench. Page 130. This is the one batch of the applicants who have already protected, whose pay has been protected by it. 130. And also page 140.
You are not a CDPO.
I was acting CDPO. Because this particular ballot, I need to take back.
Acting CDPO?
Yes. I'll also pray your lordship. Then after ballot, finally go to page 141. That's a continuation of the parent order.
So then, since this order was passed and you are a party to this proceeding,
This order of the WPST 104, the one batch of the applicants who are before the tribunal being agreed with the decision of the reduction of a pay.
So this is not a order passed in your rate petition.
That is not passing.
You are not a party to that.
I am asking equity on such ground. And for that reason, I preferred an MA with regard to the reduction is concerned. The MA has taken into consideration, then after the contempt ballot. So I'm asking equity on the ground of.
What was OA 334 was filed by whom?
OA 334 is filed by the applicant who is petitioner hearing. And OA 864 of 2016 is the identical different.
No, that we have understood.
Yes.
Now you are claiming parity with someone who has been granted a relief in 2020.
Yes. That's
so, but what was the substantial relief in OA 334?
Kindly come to 120 of my MA application. Page 120, Lordship. Para 11 and the prayer.
We asked you what is the substantial relief in the OA.
OA ballot, I have not annexed ballot because we are aggrieved only by the MA order ballot. The OA is at the final words of hearing ballot. They have been taken into consideration. They have been co-jointly. The matter has been substantially heard. And the order ballot I am producing, your lordship, kindly see the order. Kindly the recording of the State Administrative Tribunal order ballot at 144.
Why can't you just point out the prayer? It is there at page 116. Your substantial prayer in OA.
166.
116.
116. Okay, I have set out my.
When we want to know something and it is there on the record, why you should not show it?
That is set out. I have set out. The prayers have been set out.
Ways of which year?
That is of year
2020.
ballot 2020.
2020. MA4, where is annexure MA4?
That is at page 153.
So how do you agree by this order? This is an order passed in respect of those who were writ petitioners in WPST 104.
No. So far as this particular part is concerned, my lord, it is a protection to those who are petitioner before this.
Correct. So in the MA, what are you seeking?
MA, my lord, I am asking for, then after, my lord, the pay protection is applicable only to those assistant CDPO who joined in their respective place of duty within 7 days from such and such. The day of the passing of Honorable High Court, the order has to concur with. Well, this
They
is
had no option. They had to issue that in terms of the High Court's order. Then.
Yes, they have issued the protection only given to the petitioner.
Yes, because that is what the High Court said.
Yes.
Limiting it.
Limiting.
Yes.
But I am also standing in the same footing before the tribunal, my lord, and the Honorable Tribunal has already recorded my contention. It has kindly go to page.
But that is your substantial relief.
That is by substantial relief.
So how that can be granted by way of an interim order? That was granted. That is your substantial relief. You are saying that after becoming a CDPO, your pay has to be protected because prior to that you have discharged duty as CDPO.
Yes.
This is your case.
Yes, my
So you are claiming parity with the writ petitioners of WPST 104 of 2020.
Yes.
Now that is a substantial relief.
No, WPST 864 of 2016. Because two petitions is pending before the tribunal. That is OA 864. The OA 864 applicant got the protection. They are the identically circumstanced person.
And 104 is not similar to you.
No, they are not senior, man. They are the batch. They are the batch.
They are not similar to you.
They are similar to me.
So both have.
And since they have filed that application, I was not a party. Thereafter, I filed a subsequent application.
Where is the order passed in 86?
I beg your pardon?
WPST 86 order, where is that?
WPST 86.
Just now you showed us the order passed in 104. Now you are saying 86.
No, 86 ballot. 864 ballot.
864.
Yes.
Where is it?
The 864 order is this ballot. That is at page 130.
That is 864.
Yes, this is the against that particular original application. This is the WPST 104 arising.
So when we say 104, you are saying 864. It is order passed in 104.
The original application before the
Why are you mentioning the original application? You are relying on order of the High Court in 104.
Let it be 104, Lordship.
It is. What do you mean? Let it be.
No, because the 104 is arising out of the OA.
It may arise out of anything, but the order is passed in 104.
And I am asking the parity on same order, man.
So therefore, that is a substantial relief claimed in the in your OA.
Yes.
In the MA, what is your prayer? Now let us
MA mallet, which are subsequent, these are the action which is subsequently has taken place. So
Yes.
therefore, I constrain to file the MA
Yes.
to give the protection with regard to in akin to the provisions of the WPST 104.
So therefore, substantially you are seeking the same relief by interim relief.
It is the same matter, mallet. Both the matters are same. Even your Lordship will go by the tribunal record, mallet.
If you have 2 minutes patience, then you will understand what we are trying to say. We don't know whether you are similarly situated. You are claiming to be similarly situated. You are very, very emphatic that you are similarly situated. There is no difference.
Yes.
There may be. But that is a relief which you are claiming, that it should be declared that you are similarly situated and same relief should be granted to you. Are we observing anything which you are not in agreement with?
Mallet, my disagreement with regard to
Yes.
the original application.
You are not claiming parity with 104
No,
petitioner.
I'm praying, mallet.
Then what is it?
No, my prayer is this, mallet. I am asking for the redesignation to post me as an acting CDPO.
So you are claiming parity with petitioners of
And
104.
since the one batch of the persons has got the protection, mallet, I
Correct.
am asking on the same line of protection.
You may say it in as many ways as you want. But the thing is, you are claiming parity with those who are petitioners in 104.
Yes.
And that is your substantial relief in the OA.
Yes, agree.
Now you have filed an MA.
Yes.
So in the MA, what is the relief that you are seeking?
MA, mallet, that's the relief.
120. Same relief.
No. The applicant pray before the Honorable Tribunal to pass an appropriate direction against the respondent not to take any coercive action in terms of the notification number 3821 dated 22/11/2023 and memo number 1572 of 8/5/2025, because these are the developments which taken place after the filing of the original application. Mallet.
What are these two orders?
Yes, mallet. These two orders, mallet, the one order is page 153 and the one is 156. No, 156. The 22/11/2023 is the protection conferred only to WPST 104. Thereafter, mallet, where I prejudiced, that is at page 156, where the petition number 6 is there. 8/5/2025. Here they are taking action with regard to those who are not the petitioner before the WPST 104. And that thing culminated into the deduction of the pay. I'll also peruse my lord 158 also. That is the petition number 5.
This Abhijit Ghosh, whose name has been mentioned in this communication, he is petition number 5.
Yes, the petition number 5 is mentioned, my lord. Petition number 5 name is mentioned in this 8 page 158.
Abhijit Ghosh.
Yes, my lord. No, 58 my lord Sarat Kumar Hazra.
And in 156.
And 56 my lord Abhijit Ghosh.
Both are petitioners.
Yes. And then after my lord, kindly also see my lord page 183. That is the culmination of entire thing.
So what order the tribunal passed on the MA?
The tribunal, my lord, the tribunal passed an MA. That is as page 161. No, 160. What did I do?
Yes. So according to you, this order was not complied.
Yes. And that is already reflected in the order impugned, my lord. That is at 5/8/2025, the last page of order. And also there is a shifting from the main order, you know.
Yes. Yes, Mr. Mukherjee.
So far,
For recovery of salary or reduction of salary from them, show cause is being asked from the CDPO.
no, because they in the constitutional they have said they're acting as a CDPO.
That's not the point. They are the affected persons, and show cause is being asked from their higher authority.
No. And see the so called notice? Page-
Kindly see. Come to page 156.
Yes. 156, child paternal on that Abhijit Ghosh. Abhijit Ghosh, he is holding the post of child development project officer.
Who is asked this question? This question is being put to Abhijit Ghosh or someone else?
Abhijit Ghosh.
Show it.
No, but-
Then we'll record that the show cause has been issued to him.
No, but
Should we record your stand that show cause has been issued to him?
No, like frankly speaking, my lord, it should have been addressed to the Abhijit Ghosh.
Exactly. That's what we are saying.
If my understanding is wrong, kindly correct me.
No, therefore we are saying if we can record that the AGP says that this is a show cause to them, the matter will finish.
No, when so cause notice is issued by then by
If
name,
they are to be affected, they have to be issued a show cause. How can it be without issuing a show cause?
my lord can dispose of the application directly in the department to issue so cause by name, not by official designation.
But the point is it arises out of a contempt, non-compliance with the contempt order.
And the content has not been decided.
How long you have worked as CDPOs?
From 99 to 2020, at least.
So these facts are there in the way.
Yes, sir.
99 to?
From 99 to 2020. And my lord, the pay, just to back where your lordship is asking, my lord, when the 1990 they took a decision to posted me for to perform the higher responsibility, till 2008, my lord, I worked. Then after I preferred an application before the State Administrative Tribunal for the pay parity, which was not granted. That assailed through the Honorable High Court and it went up to the Honorable Apex Court. By virtue of the Honorable Apex Court order, the entire pay of the persons who are performing the higher responsibility has been decided by the Honorable Apex Court, and it was conferred. Matching order was also issued. The person who are left over from that particular Supreme Court, they filed a separate application before the State Administrative Tribunal, and the State Administrative Tribunal, taking into consideration of the Article 141, they passed an order and all the persons who are the petitioners herein got the scale number 14. Then the entire dynamics was changed, my lord, in the year 2020, where I constrained to file the application, as well as the 2025 when my prejudicial action was started. I preferred an MA application for protection of a pay on the ground that the similar circumstance person has been protected and the matter is pending before the Honorable Tribunal for the final adjudication.
So once you have succeeded up to Supreme Court, why did you go to the tribunal?
No, my lord, this is the pay protection, my lord. This is the pay they have granted, and they have taken pay was granted by the Honorable Apex Court. This scale number 14.
But they are not party before the Supreme Court.
So we are asking him, if you have already obtained the relief up to the Supreme Court, why you have filed the OA?
My lord, the Honorable Apex Court, only the 14 persons who are before the party before the Honorable Apex Court.
So don't say you do, there is no order for you prior to the approaching the tribunal.
Yes. So far as Lordship asking the fact.
Others may have got, those who were diligent, they have got in 1990 or 2000, whenever they have
And
got.
we also got the matching order from the state administration.
Where is that? Where is that matching order for you? And if you have already got it, why this MA has been filed?
Because thereafter, my lord, they changed their stance.
So let us see, where is that granted to you? Where have you said in your OA that earlier an order was passed on your case?
Matching order was restricted to the order passed in the Supreme Court.
He can't be. If he had an order, he would not have gone to the tribunal again. He would have filed a contempt. It is quite obvious. Show, please show. You have said that you have got an order in an earlier proceeding. Show us.
That order, my lord, I'll produce you also.
Where is the averment in your OA? How do the authorities know that already such a benefit has been conferred on you by any order of any forum?
Since, my lord, I agreed by the MA.
And if it is not there, how are you telling
Since
us?
I agreed by the your lordship has asked the background of that thing.
So from where do you get the background? That is what we are asking you.
I'm aggrieved only by the MA order, my lord. The background of that thing has already pleaded in my OA application.
Let us see. That's what we are saying. Show from your OA.
OA is not annexed, my lord, because I agreed from the MA and the contempt order. Therefore, I constrained to file only those. Because the main OA is also before the Honorable Tribunal, my lord. That has not been attained to finality.
OA you have filed in 2020.
Yes. I filed the OA.
Then what is, when you are claiming the relief, just come to your relief in the OA. If somebody has got that relief earlier, he will come for the same relief again. And can he come for the same relief again if he has got it earlier?
The background of this story, my lord.
Background is others have got it. Say that others have got it. If you had got it, you would never come again.
No, my lord, they got the order from the Honorable Apex Court. Then after
others have got it.
Then after, my lord, on the same line of action, plenty of application filed before the state.
There may be hundreds of applications.
Yes, and they got
we are only concerned with you.
That order I'll.
You are to tell us about yourself.
That order I will produce you also. Because
there is
I
an
got the
order-
order, the pay parity with regard to the Supreme Court petitioner's, my lord, by virtue of the State Administrative Tribunal's order. And then, my lord, this particular for the permanent
I
resignation.
don't know how you are making these submissions. If there is nothing on record, how can you make such submissions?
I'm honestly saying, my lord, because the cause of action is pertaining to the MA and the contempt, therefore I not annex this OA, my lord. My only submission would be there was a parent, the MA application, which was a clear-cut direction in a MA before taking into any adverse action with regard to the reduction of pay, you need to issue the so cause. That has not been issued, and they reduced by pay. In a content, my lord, I preferred a content application. Here, the content application taken a dust office view and the proponent, whatever the landed.
So what happened after that?
After that, my lord, the tribunal is not in session, my lord.
What happened to you after that?
They have reduced my pay.
Already?
Yes. Kindly come to that order impute.
Where is that?
Yes, sir. I'm coming. This is one of the, my lord, page 183.
183.
183. Jyotindra.
183, he is a petitioner.
Yes, 9.
So only for one petitioner there is.
Because these are they are taking one by one, my lord. Therefore, I constrain to supply the supplementary affidavit.
No, we are asking you, has it been issued for all the petitioners?
tentatively, all the petitioners, they have not issued, but one by one they are doing. So far as this supplementary affidavit, it has been reduced with regard to the petition number 5 and 6, Your Lordship.
So how many petitioners the order has been issued?
Total ballot, here is a 11 petitioners. With regard to this ballot, the 4 to 5 persons has their pay has been reduced.
You have to tell us the specifics. If we are to pass any order, we must know the specifics. You cannot say 4 to 5 and 6 to 8, because then there are two class of peoples.
No, my
By
prayer,
one sweeping order, so nothing can be done.
what is my prayer ballot? Kindly go to the writ petition which I have. Kindly just peruse the prayer. Prayer.
By order passed on a miscellaneous application, the tribunal has directed for furnishing a show cause. And after considering the show cause to take action, in the contempt, the tribunal has accepted the stand of the state that there is no question of issuing show cause because show cause was to be issued to CDPOs. This is your case. Now you are saying in this circumstance, because of the contempt court, in a way, reviewing the order passed in the MA, we have been visited with certain order. Who has been visited with the order? Why are you going in history? Show this. How many of you have been visited with the adverse orders? How many there is an apprehension? Come out with a specific case.
9, 5, 6, and 7.
9, 5?
9, 5, and 7.
There is no order for others.
6 is also valid. No, there's no order for others. They are taking one by one, Malik. They have not passed any uniform order with regard to all the petitioners.
So this is the order which is being passed for everyone. Same order, in more or less same.
More or less. Only the mutatis mutandis, the name is concerned, or the ICDS project, etc. That will be changed.
Yes. Yes, how it can be done?
Kindly see page 39, prayer C.
Yes.
A retain the number mandate, right in the respondent number, give effect to the WPST number 14 of 2020. The outcome of the petition number on 2020 versus on WPST of 14 of 2020. Until unless final adjudication is made by the tribunal, the WPST number 104 is applicable to them, which has been affirmed by the Supreme Court. There must be some adjudication that 104 is applicable to them.
How the tribunal can review its own order passed in MA in a contempt proceeding?
No, they review contempt proceeding, you cannot review the order. Then that's a certain principle. But only ballot, they were the drawing and disbursing of stuff.
Those issues are yet to be determined. They may not get the relief. We don't know. They may or may not get a relief.
Yes, we do not know.
We do not know. But then when there is an order of serving the show cause, see the order passed in the MA, then how it can be ignored?
151. On 53, they have challenged. 153, that is at 22nd November 2023. That is restricted to those who are covered by the Supreme Court order. Terms of the order dated 28th December 2021 on High Court at Calcutta in connection with WPST number 104 of 20, Assistant Child Development Project Officer, who are the petitioner in WPST number 104 of 20, who draw pay salary pay scale number 14 under WPST scale from Assistant CDPO only, who joined the respective certain date from 22nd to the date of passing of the order by the High Court order, Congress of the Department. Then 154 so cause note. Ordinance of Chattopadhyay, Askari. PDPO Askari is drawing disbursing of the draw space case in favor of the ordinance of Chattopadhyay.
Where is that? Which page? The
Page 154.
Where they are issuing orders against the petitioner number 9 or 5 or 7?
That is as 183.
183. July 23.
This is the day before yesterday order with regard to the reduction of petition number 6 and 7. কত? 7.
Have not been sorted.
Yes.
Okay.
Only that your document which I have annexed. That is the reduction.
July, August, September, October, November, December. 6 মাস হয়ে গেছে।
So from 14, you have been brought down to 10.
Yes.
Without any show cause.
But he is drawing the pay scale as a drawing a disbursement.
We don't know.
Intimation.
You never challenge the order passed in MA. You never challenge the order
No,
passed.
MA has been fixed. Pending, still pending.
No, MA is disposed of.
No, MA has not been disposed.
Huh?
At the admission stage.
MA, not
The admission stage.
not OA, sir. MA.
Let this matter appear on for hearing admission hearing.
The heading hearing on 10/7 anyway.
Page 161. 161.
So you have filed a reply before the tribunal. Take down.
Item 26.
Yes.
Lordship, Mr. Dinda is appearing for the state, Lordship.
Who?
Lordship, Mr. Dinda is appearing for the state. Due to personal difficulties, he cannot attend court today. So praying for a not today, Lordship.
Have you taken consent of the other side?
That was my instruction, Lordship.
It's not a practice here.
The day one, the students are passing the law, they have been infused with a feeling that if I wear a coat and a gown and I come to the court, my only object is to get a case from a client. And then this is how the things are going on. Miller, I still remember that I attended the chamber of my senior Miller, Mr. Ashok Dey, a senior advocate of this honorable court, for 15 years. And I had to attend his chamber from morning 7 till night 12. And when I used to come, the dogs were barking at the initial stage. Then the dogs were not barking, looking at me.
Nowadays they study for 5 years.
আমার কোনো তোমার অসুবিধা তোমার কালকে হলে অসুবিধা হবে not today বাস ঠিক আছে আমার কোনো অসুবিধা নেই ঠিক আছে
Very well.
The matter will appear tomorrow.
No, it will come on Monday because WPST is on Monday, Tuesday. So if you want any other day,
No, Monday. Let it be on Monday.
Monday it will
get. But this is that matter. Just 1 second, Lord. Kindly do not take me amiss. Lord, the selection conducted by Public Service Commission. Now, what was hinting my mind to go into the rules to find that whether the Public Service Commission had complied with the rules at every stage. Now, on the other day when I made the submissions and your lordship recorded an order to produce certain things by the Public Service Commission, now that time, Milord, the rules were not with me. Then subsequently I find that there was a breach of compliance of the particular rules by the public. That I will show to my lords, Miller, when the matter will be taken up. Miller, this is the thing, Miller, what I want to say, the more time we give in a brief, the more we try to catch up many things from the matter. We are every day learning from my lords, but at the same time, we are after giving the time to the briefs, we are also learning many things.
There is mutual enrichment in the
Of course,
courtroom.
of course. I'm grateful.
$27.
27, I am for the petition. But I have been briefed in this matter, but my lord, I do not find the impugn order annexed herein. But I do.
What is not annexed?
Impugn order.
Oh, it is there.
Then very well. Uh,
It is of 7th August 25.
yes, ma'am. It is not here.
So there is a direction to give compassionate appointment.
No, my lord, it was rejected.
So you are for the applicant petition.
Yes, ma'am.
What is the date of demise and who was the deceased? Your father or
This
husband?
was my father. In the year 2020, my father was died. Thereafter, in the year date, my lord, 10th of February 2000.
2000?
Yes, ma'am. 2000. I made application on 21st April 2000.
You made application?
Yes, ma'am. But after my application,
yes.
But thereafter, last 16 years. What is it? Yes. That is 648.
Where is your first application?
My first application is at page 21. 20.
20.
Yes, ma'am.
Not your application. Some communication from the chief health officer.
After application, this communication was made. Next application is 2016, 21.
is only a covering letter. Where is the wrapper?
Not any.
Because it says enclosure as above. That means it should have been enclosed.
But it is there, but he says client does not have this application. Only communication letter is there as on date.
Oh, this page 29 is the order impugned before the tribunal.
Lordship.
Page 29.
Lordship.
So tell us what is wrong with this order.
Page 29, the order was passed by the Director Health Service.
So this was impugned before the tribunal.
Yes.
That's what we are saying.
Yes,
so let us see what is wrong with this order.
Lordship, first contention that I have submitted my application within 2 years.
Within
2 years as required.
Yes, it was rejected on 15/12/2000.
But it was not communicated to us.
You have said so.
Yes, my lord. If your lordship sees page number 24, we have filed another way. Thereby, this contention was again rejected by stating that the communication was not made to us. That's
Page 24.
Yes, my lord. And again, direction was passed.
No, this is an order passed by the additional chief secretary. This is not an order passed by the tribunal.
Yes. Yes, lordship. Additional chief secretary. Then the last paragraph. Now there are therefore it is found that Tarun Kumar Bhuiya, son of no, I'm wrong, my dear. It was my reference given that due to lapse of years, my lord, that is not the ground for rejecting my application. But my contention was that I have filed application within 2 years. The authority kept it quiet in this matter. Thereafter, again, when I approach before the court, they are coming with the ground that uh, you said for
Where is your OA? Is the OA copy is there in the record?
annex for but kindly give me liberty to file a supplementary affidavit.
Just a minute, just a minute. OA was filed in which year?
By 2022.
22.
Yes, sir.
And you are the applicant.
I'm the applicant.
So in the OA filed in 22, you have mentioned your age as 35. And a writ petition filed in 25, you have mentioned your age as 50.
Yes, my lord. This.
So in 3 years, you have grown by how many years?
Yes, my lord.
15 years.
It was a wrong committed by the trial court lawyer, but I have annexed my admit card appearing at page number 13.
Huh?
From there, my 30.
13.
30. But from there, my age could be ascertained.
13.
30, my lord. 30. 9th day of January, 75.
31, what the admit card 31?
30 is the Director Health Services order, sir. Everything is
Date of birth.
But in the affidavit in OA, it was written wrongly. I should be candid before your lordships.
What is the date of examination in this admit card?
It is not written here.
That's why we asked you. Admit card mentions your date of birth, but does not mention the date of examination.
1991. 1991.
But I do not see anything, madam. May I file a supplementary affidavit with other documents also?
What supplementary? This was before the tribunal.
No, it was not placed before the tribunal. It was not annexed, no. At the day of delivering judgment, it was placed. এটা ফোর্স দেওনি তো এটা ফোর্স না তো এখানে
In 1991, the West Bengal Board of Secondary Education was giving a computer printed admit card. Have a relook before you argue the matter.
Pilot.
In 91, we don't think that computerized printout was.
But let me inquire first.
Not today.
Grateful.
91 computerized admit card was being issued.
Twenty-eight, I am appearing for the applicants. Order passed by my Lord Justice Tandon and my Lord Justice Vishwas. A similarly situated person got the appointment in terms of this judgment and SLP in the Supreme Court after dismissal of the SLP done. Other than Mr. Kusumalik was there when he admitted that some compliance was there, but in respect of my client, there is no communication, no appointment, nothing. We are in dark whether we have given any appointment letter or not. But in terms of the order at page 70, operative part, page 70, operative part I am reading. We therefore set us page 70 of the application. Already 65, I believe, or 63% have been given appointment in terms of this carried out. We therefore set aside the order trial court and which in disposition was dismissed such and such. Therefore, said appeals are disposed of, directing the authorities to prepare a panel on merit wise, and which could include all the candidates of the unreserved and reserved category. And in the event any applicants are found having obtained more marks than the last cut of marks, as disclosed in the writ petitions, they shall be given appointment exclusive vacancies. And
the requirement was to rework.
Yes.
And if you emerged successful, then to give.
Then, well, now we are in that. What is the compliance?
Things is that, my lord. Please, down.
So you have stated that after this, no such revised or list was published, merit panel.
Published, what happened, my lord? Total 78% list was prepared. Thereafter, my lord, it has been sent to the office of the Commissioner of School Education. Wherein after scrutiny, my lord, because the cutoff marks was 38.777. Finally, see, my lord, it has been mentioned, my lord, in the event any of the applications are found having obtained more marks than the last cutoff marks as disclosed in the writ petition, they shall be given an appointment. Now, my lord, there are 16 candidates, my lord, who has not come within the zone of consideration. That is 38.333, 777. Now, some people has obtained 35 point something, 28, 34. So they have not come within the zone of consideration. So that is the reason, my lord, 63 has got the appointment. 16 has not got the appointment because of, my lord, this.
They are out of the zone of.
Out of zone of consideration.
Below cutoff marks.
Below cutoff marks.
From where can you show this?
That's why, my lord, this is for the first time it is appeared.
First time.
Take instruction.
I said, yes, I have got the instruction.
There must be cutoff marks. There must be above the cutoff marks. They must prepare. I believe that list itself. Otherwise, how can I know?
See, the direction was to prepare a panel.
Yes,
it to be there.
There is no panel prepared.
Yes,
appointment given, but we are not been communicated to anything. We are to.
If a panel is prepared, it is notified. Where is the question of communicating?
No, subject to correction. That belonging to all scheduled caste category, they have not prepared.
We are not on that. We are saying the direction is to prepare a panel, include all reserved, unreserved, and if they come above the cutoff marks, to give the appointment.
Yes.
So first thing is whether panel was published or not.
Published.
Then why you are saying you don't?
No.
Yes.
Published, but
so if the panel is published and your name is not there, obviously you are below the cutoff mark.
Otherwise, we have the right to know why we are under the zone of consideration.
But that is not the scope of a contempt.
No, it is there. Well, kindly see, obtain more marks than the cutoff.
That is not the scope of contempt.
The contempt explaining that. Because we are in a dark, we do not know anything about
darkness.
Huh?
It has been clear in the order.
Preparation.
There is no question of for such information can you resort to a contempt proceeding?
We have subject to correction. We have made RTI application to them.
They will respond to that. They will respond to that.
If let them file a compliance report, where they have done in that manner itself.
See, unless the moment they have published the panel, the contempt goes.
No, they have published, I believe so, in the general cast. Let them come with that report.
This has been done by the commissioner. I have been with
let them come.
Mr. Basu.